Mr. Plani.
Good morning. I'm the registered clerk for this morning, for this hearing. Justice Madlanga and justices of the Constitutional Court, all counsels are online. I call the matter of Transnet, SOC Limited and Total South Africa Limited and another. For hearing, counsel are now invited to place themselves on record. Please note that this hearing is being recorded.
Thanks, Mr. Plani.
May it please you, Justice Madlanga and members of the court, Jeremy Gauntlet with Kameshni Pillay, SC, Frank Pelser, Yanelo Ntloko, and Nomondi Nyembe appearing for Transnet.
Thank you, Mr. Gauntlet.
May it please the court, Justice Madlanga and Justice of the Court, Azar together with Advocates Babamia and Hofmeyer for the first respondent, Total.
Thank you, Mr. Baum.
May it please you, Justice Madlanga and members of the court. My name is Termination. I'm with Mr. Duncan Turner and Mr. Michael Mbegiwa for SASO.
Thank you, Mr. Toby. Yes, Mr. Gauntlet.
Thank you, Justice Madlanga, members of the court. The court has asked for oral argument as to whether leave should be granted, and if so, whether the appeal should succeed. With your leave, what we would like to do, particularly in our introductory 10-minute period, is to focus on the core of the case. What is the core of the case? Because when one has established that, particularly in relation to the two legal issues which present themselves, then in the light of that, one is able to assess whether or not there is compliance with the criteria for leave to appeal, and of course, whether on the merits themselves, there is a sound case. As the members of the court know, the case concerns a contract which was concluded in 1967 and varied in 1991. I want to stress that it is one contractual relation which is divided, as it were, into two historic parts. The original one, which incorporated the Neutrality Principle, and the 1991 variation agreement, a variation agreement because it was adapting, changing, or purporting to do the initial agreement. Each only comprises two letters. Each, it is quite apparent from the terms of the letters themselves and from what is generally before court, were dealings between officials. There is no indication of lawyers being involved in the drafting. Sometimes it improves drafting, but it is certainly a factor which to be borne in mind in seeking to interpret what was meant between the parties. What all this concerns is a massive piece of governmental infrastructure, which was seemingly built in the 1960s, and which you would see from the record, volume 3, page 261, spreads across the country, runs from Durban, west, up north in one branch to Volksrust, and in another branch, more east, more west, through Sasolburg and ending as far west as Klerksdorp. Now, this massive piece of infrastructure was then the subject, as you know, very shortly, of the Neutrality Principle being determined. The circumstances in which that happened are not new facts, as is from now and then suggested by the other side. The facts are usefully recorded on one page, in the volume at page, the first reference I should have given was volume 4, page 295, the one which sets out the type pipeline. The page which gives you, in an absolute nutshell, the history, background to the 1967 agreement is volume 3, page 261. That's an internal letter between Sasol and Total, or vice versa. The point about it is it reflects exactly what we have said, that it was a transaction involving essentially a French oil company at a time when France was engaged largely with countries like South Africa, Israel, and Bhutto's Pakistan in various outreach attempts. And the point was to enable crude oil, as you know, to reach the strategically located Natref refinery at Sasolburg. Strategically located because there the oil from gas and the crude oil coming from the coast could be refined in South Africa itself in the hinterland. And the neutrality principle, as you know, sought to do a simple but elusive thing. It sought to create a kind of a fiction that the Natref refinery would be on the coast in all its treatment, and that as regards tariffs, it would be so treated. The next step followed really on the record some 55 years later. The 67 agreement with that neutrality principle stood. It stood alone, but not happily. Again, if you want to find where that is documented on the record, you find it in the witness statement of Mr. Crowley, which is in the old volume 6, page 449 to 450. And you will find in his transcript of his evidence in volume 6, 469, line 12 and following. Sasol made veiled threats of pulling out. There was clearly dissatisfaction as to whether that neutrality was being achieved. And so it came about that just as happened in 1967, there was once again an exchange of letters intended, I stress, to have contractual effect. And those letters then brought about that which Justice Soka interpreted in the way he did, to which I shall come in a moment. Now, what he did was, and this is absolutely at the core of the interpretation issue, is what he did was to hold that in his judgment, that no issue of perpetual obligation, no issue of evergreen arises, because all that Transnet had to do, if it wished to terminate, was to prepare and produce a full agreement. Now, could we just pause and examine that? Because it's absolutely crucial as to whether or not you find that that is a sound and viable interpretation, either at the merit stage or whether you hold at the earlier stage that it is within the interests of justice because we've got a reasonable prospect of showing that that can't be right. May we respectfully say that that conclusion cannot be, in the language of Indomeni and anything else, commercial and sensible, because what it purports to do, according to Justice Soka and defended by our adversaries, is to require of Transnet simply to draft an agreement and to hand this agreement to the other side. Could we quickly point to these fundamental absurdities? Number one, the clause clearly as a dominant provision is intending to give a right to terminate. How logical can it be that in exercising a right to terminate, you must hand over that which is capable of signature as a new agreement? First point. Secondly, it amounts to an absolute absurdity, we would say, in the words full agreement. If I hand one of the justices an agreement in these circumstances, and I say it's full, what does full mean? There's never a full agreement until the other party signs. There's never an agreement logically until the other party signs. The one party may say there's no arbitration clause, there's no acceleration clause, this is not full. Or it may simply say, thank you very much, but from where I come from, there's no agreement until it is signed. Or it might cynically say, yes, all right, we'll sign that agreement, but you don't know whether they will or they won't. And then you have the problem that there you were seeking to terminate, and the other party says, thank you for your agreement, we've concluded it, and you've locked in. We say that with great respect. For those reasons, Justice Soka's answer, which was given to our side of the case, don't worry, it's not perpetual, it's not evergreen. There's a way of getting out, and the way of getting out is you simply hand over an agreement in those terms. And we know from you, justices, from Mokati and Vodacom, that of course you've got a contract in good faith. So we couldn't cynically put up that which we would know would be unacceptable. We'd have to put up that which in good faith we believed could be acceptable. But we would never know, because from the other side of the coin, the parties would say, but this is missing, that is missing, or simply, we don't find that in the interests of our parties to agree to freedom of contract and its deep roots. So what is the second possibility? And that is that Justice Soka, with respect, was wrong, that it is an evergreen contract, that it is the Russian doll of which we have spoken, that you come to terminate an agreement, and you terminate an agreement by entering into another agreement, which must then contain what is in the terminated agreement. We say that two things about this. First of all, the more we've looked at this case, the more we are concerned as to whether this court, applying what is done before in Azapo and Matatiel, Azapo in paragraph 16, Matatel paragraph 16, would hold that legality is always for the court. And a court is always entitled to say, I'm sorry, this makes no sense. We can't enforce this. And that's one answer, which we'll deal with later to the case. The other, of course, is that that is an evergreen contract. And what you have here is, in the end, the legal anathema that you have a 1967 agreement, pre-constitutional, obviously, varied in 1991, obviously pre-constitutionally, which a party brings to court in the 2000s to seek to have enforced. And it says, well, look, of course I'm not going to comply with procurement. Of course I can simply do this. This back of the envelope kind of two-page agreement relating to what was in derivation a national piece of infrastructure, and even now is one which is conducted by an organ of state. And one just has
at that point, Mr. Gauntlet, the 10 minutes is in fact 11 minutes, in fact.
Thank you. Retrospectively, I've lost my diplomatic immunity. Thank you, Justice.
Thank you. Thank you.
So the short point then is that scenario conceivable, that by virtue of this mechanism, one is able to say that this organ of state dealing with this piece of equipment, substantial equipment, is not hindered in any way by procurement requirements. It's not required to say to the other oil companies, look, this is the situation. What's up for consideration is the use of the pipeline. What offers do you have to make? Or to other entities able to use the pipeline. So
but how do you interpret the subject to, Mr. Conte?
Could we in fact, well, let me go to it directly. Yeah. If we go to the clause, which we replicate in our own heads, and perhaps it's the easiest place, page 6 in paragraph 15, it provides that each party shall give the other at least 3 years' notice of any intention to disregard the contents of this letter of agreement. Could we take it slowly? The first thing the court will notice is, as I indicated earlier, the rather non-lawyerly terms of saying you have the right to disregard. everybody in the case understands it means that you can terminate. But it is a warning to all of us, be careful as regards trying to give term of art meanings to particular words. Then it says, subject to the arrangement that a full agreement of conveyance for crude oil is being prepared. To answer Justice Madlanga, we say that subject to is that there's an arrangement which is reflected again in the second letter, that such an agreement is being prepared. And if you go in the record to that second letter, which is in volume 2 at page 132, and you've got to read POC 3 with POC 4, it says, we confirm that the conditions as set out are acceptable to us. Our understanding is that these conditions will now be incorporated in an encompassing agreement between ourselves and Petronet, Transnet. It is our understanding that Petronet will draft such an agreement. We say that not only on the rather more technical basis of the present participle that the agreement is being prepared, but clearly interpreting sensibly and properly what you read at page 132. What was contemplated by the parties was that at that time, there would be a fuller agreement being prepared. It did not contemplate that there would be, and on the facts, both parties just left it there. And may I say why? On the facts, we shall show, and it's an aspect which causes great fury in the ranks of Sasol and Total, but on the facts before you, the problem which had emerged by 1991 is that the application of the neutrality principle was generating significant profits which on the figures of Total or Sasol show 20 million a year. So it wasn't working, which is why, and also on, may I say, our learned friends, heads of argument, acknowledged there'd been many attempts to find the mechanism for the neutrality principle. So the parties were unhappy. And what do they agree? They agree that a party, any party, can get out, which of course then includes Transnet. And it can get out, and comes now to Justice Madlanga's question, subject to, they were saying, we've exchanged these two letters, but we do need a better and fuller agreement. We say that it is being prepared and that it will embody the contents of this letter and supersedes the letter. It never happened. Now, it wasn't enforced by Total and Sasol. Why? Because on the facts, they were doing very nicely. This neutrality principle was yielding them on their own figures up to 20 million rand a year in what is, on Transnet's approach, a windfall. They shouldn't have been profiting on the conveyance. They should simply have been treated on the basis of equality so they wouldn't be disadvantaged in comparison to the coastal refineries. So that was what was contemplated, Justice Madlanga, was an agreement being prepared at the time. Not that you would never in the future be able to get out if the agreement wasn't prepared by preparing an agreement at that time. It was an opportunity which was put in for both sides. Both sides let it go. What was pleaded by Transnet is that there was an election in this regard by Sasol and Total. But the short point is that the dominant provision was that you could terminate on the basis of this arrangement. And then you come back to Justice Soka, who says, well, that's not a problem. You just have to send the other side what you say is a full agreement. And that can't be right, because even assuming on the McCarthy principle that you act entirely in good faith, as I've said, there's no mechanism created to be able to pull that off. So we say that is the conundrum, the fundamental conundrum at the heart of the case. And just to sum up.
Yes. Let me listen.
Yeah,
to this.
just to sum up, we're saying that there are three possibilities. One is that Justice Tsoka, in spite of what I said, is right. All you have to do is to prepare a draft agreement. And you send a draft agreement to the other side and either cross your fingers that they do sign it, or maybe you cross your fingers that they don't, but you send that to the other side. And we say that that can't be sensible for the reasons that we've argued. The other is then that you're stuck in there with this continuing, as it were, revitalized 1967 agreement, and that in the circumstances, you are in a perpetual obligation. The third possibility, Justices, and it's a very serious one, is that you are in the position where you say that it does not appear with reasonable certainty what in fact the reciprocal obligations of the parties are. The Azapo and Matatiel position, before that Yanako versus Apollo Club in the then appellate division. And the court says, well, I don't mind what you plead, either of you, but how can I enforce this? It is insufficiently certain. And this court, on a matter of legality, would always be free to say, well, in those circumstances, I can't order enforcement because I can't be bound to two unsatisfactory interpretations, and I don't order that. Now, Justices, with your permission, before I turn to the leave to appeal criteria, may I
wanted, Mr. Condet, I wanted to find out if, on your interpretation, that means the very afternoon, assuming that POC 4 was received in the morning by Petronet. So in the very afternoon of that same day, that Petronet could have given the 3-year notice to terminate.
That's the encompassing agreement. What POC 4 is saying, no, there must be an encompassing agreement.
Let's say the Petronet was already keeping it in their top drawer.
Oh,
Ready for a response, and then upon receipt of POC 4, they pull out the draft out of the top drawer, send it over to the other side, and then say we are simultaneously giving a 3-year notice.
Yes. In those circumstances, if leaving aside my point, that isn't sensible to have what is simply a draft agreement which the other party hasn't seen, hasn't agreed to, and it just comes out of the drawer and goes. But put that point aside. If that's not right and it's good enough just to send over a draft agreement, then yes, the 3-year notice period can be given. But that's our argument is that with respect is crazy.
That's not.
Yeah.
Okay, all right, I get that part of the argument. I get that.
But Justice Madlanga, I'm very grateful to you for highlighting something I was going to come to, and there's an important aspect of understanding this in staring as you took us to the actual words. Why 3 years? Well, you get a good indication again from the evidence of Mr. Crowley, because you have Mr. Crowley at the page threatening to, not threatening, sorry, saying without being challenged that in this process, Sasol was saying, well, you know, we can build our own pipeline. And why I draw attention to, that's the record at 469, line 12, new volume 6, volume 469, line 12. So that's why it's 3 years, because the parties were accepting that if you be
please that page reference, volume and page reference.
It's the new volume 6, page 469, and it volume line 12, sorry. 469, line 12. It says that veiled threat has come through every so often. So that's why it's 3 years, because 3 years is a significant period of contractual notice. But what one would have to do if you were any of these parties is to enter into a new relationship, either because, as you know, this pipeline can take both crude and refined products. It can take them in both directions. That Transnet might have had a substitute arrangement then with the other oil companies to say, well, if we can't agree with Sasol and Total, we can bring up refined products that you've refined at the coast to the inland and make it available to the motorists. And as you know, the whole point about these transportation charges, they eventually impact the public. They are reflected ultimately, as the record shows, to some degree or the other at the pump, as you might expect logically. So that could happen, or Sasol could build a new pipeline, or Sasol and Total, don't forget Total at the beginning, as is recorded in that internal correspondence. Total was initially in a relationship with the Shah of Iran's national Iranian company, and was also projecting building a refinery at the coast. So that is the point of the 3 years. And so the answer is that if I'm wrong, that it really is unworkable to say that all you have to do is to send to the other side what you call a full agreement, in which immediately then they say, well, that's not full. It misses these clauses or those clauses. And if it's a full agreement, they don't accept it anyway. But we say if I'm wrong and that is enforceable, then the answer to your question is yes. That afternoon, the trigger could be pulled and it would take 3 years. Now, justices, I need
and how do we interpret is being prepared?
Well, that's the important aspect I stressed, together with, if you look at the last sentence of 132, it is our understanding that Petronet will draft such an agreement. So what they're saying is, I would have thought on a reasonable interpretation this. One, there is no such text. Two, it is being prepared, it said rather futuristically in clause 5. And 3, Petronet will draft such an agreement. All that points to is at the time of the exchange of the letters in 1991 or immediately thereafter, not 10 or 20 years hence, which is the interpretation of the other side. Is why are we complaining? Number one, all we have to do is send a full agreement, whatever that is. And number two, that if it's 5 or 10 years later, we can do it. We say it's quite clear that the parties contemplated that at the time. It didn't happen. Both sides let the sleeping dogs lie. And we say it's quite clear why Total and Sasol should have done that, because the facts have now come out that they weren't very good on discovery, but the facts have come out on what has been put up of a profit on what was supposed to be this neutral exercise of up to 20 million a year. Now,
Justice Madlanga, with your leave, may I, Mr. Gauntlet, you've mentioned 3 possibilities as to how clause 5 should be interpreted. Seems to me that there's a 4th, and it strikes me as more straightforward and in keeping with the language. The first part is the right to give 3 years notice to terminate.
Yeah.
And the subject to clause is simply signaling that because the parties have in mind to conclude a full agreement, the letter might come to be disregarded by the conclusion of a full agreement. In other words, sooner than 3 years. Yeah. So there's a right to terminate on 3 years' notice, but of course we understand that the letter may come to be disregarded sooner than that or in a different way without notice, because we have in mind to conclude a full agreement, in which case it will supersede this letter.
Yes. Yes, Justice Rogers, with great respect, that makes entire sense. That would be a fourth. And it might avoid some of the anomalies, yes, in the other interpretations. May I then?
Gauntlet, sorry, before you go further, just to take up something you discussed with my brother Madlanga, the question of the neutrality principle, and also the question of this thing of the profits and so on accruing to Sasol. Is that part of the case before us? Because as I understand it, that was part of the so-called interpretation issue as it's termed in the heads. And that is no longer before us. You're not pursuing that. Essentially, we have two key issues to decide on the merits if we grant leave on this in this application. And the first one is your special defense, that there are no remedies in contract available. It should have been an unjustifiable enrichment. First, it should have been cancellation, but now you say it should have been unjustified enrichment. And the second one is the question of the termination of the agreement, whether it was valid termination or not. So that's my first problem. My second problem related thereto is this evidence properly before us of profits? Wasn't that evidence excluded in the Rule 20 ruling by my sister Mhlanhla J? Because the only evidence that's before us is the common cause evidence of Mr. Crowley.
Yes, Justice Majid, first of all, we should draw the court's attention to an unfortunate difficulty as between something of a divergence between the directions and the order. The order you will find at 487 in the new volume 6. And that says, as you're indicating, that it says that the disputed documents, save for the witness statement of Mr. Crawley, are not relevant. And you remember what happened was that there were witness statements, and then Mr. Crawley came to give evidence, and he gave evidence in a truncated way, seemingly, by the direction of Justice Soka. But she says here, save for the witness statement. Then she says at the foot of 487, that the transcript can be included in the record. So there's that curious feature. And then the Deputy Chief Justice, the Acting Chief Justice, made his directions at 489. And he said that the old volume 6 must be excised. The applicant is directed to file the transcript of Mr. Frederick Douglas Crawley's evidence, and then directions about revised submissions. One of the problems is, of course, when Mr. Crawley gave evidence, he referred in part, and was permitted to do, in part to his witness statement, and was cross-examined on it. That's the first unfortunate aspect. As you know, we said that in a case like this, with great respect, it should be for this court sitting en banc to make this determination, rather than to have a rerun of the problems we've had of procedural elimination in advance. But may I...
Sorry, the point, Mr. Gonta, the point you make is that question of the profits is on emanates from the transcript, and according to the order, the transcript is properly before this court. I understand what the point you make is.
But since Justice Majid, you raise it, may we ask you, because we touch on this also in our heads of argument, in paragraph 79, and we reference the record volume 3, page 254 to 5. And I want to, if I may here, ask the members of the court to note down, because this is important, to show why and how it is that this issue of profits is before you and is in the evidence. Well, first of all, starting as a matter of pleading at 3254, you will see, and I'm not going to take up too much time, but you will see that it is squarely pleaded in 254 2.2, and again in 3.1, more fully in 3.2, and again in 324, you get the figure of the 20 million. And this is taken from a intercommunication between Sasol and Total. We had to scratch around to find these things because of the economy and discovery. And then you see in 325, Sasol told Treasury of its locational advantage, etc., and what it was doing. So there are those references which are important.
Just Majid, I'm sorry to interrupt you, Mr. Gauntlet. I know you have a second question, but could I just follow up for clarity on this first one as to what is before us, Justice Majid?
Sure, I still want to get to the question of whether it's relevant, but please go on.
If you could look, Mr. Gauntlet, at volume 1, page 9, where the applicant deals with which are the issues on appeal in this court. Paragraph 15. And it says there are 2 grounds of appeal that are being raised.
Yes. Yes.
And it does not raise the interpretation defense. It raises the special defense and the termination defense. And it says those are the 2 grounds of appeal before us.
Yes. Quite right, Justice Theron. We would ask rhetorically, how could one deal with the interpretation regarding termination without having regard to the interpretation of the letters? And we pick up that in at page 21 in paragraph 52. So the interpretation issue has and this is what Crowley was trying to do, give the background and surrounding circumstances, that the two-page 1967 neutrality agreement effectively had been, from everybody's viewpoint, unsatisfactory, that profits had been made. And the contention of Transnet, and you needn't decide that now, but immediately in a sense, but that the contention of Transnet is that that's not what was intended, and that they were making a substantial profit. So when we say in our, in page to which you draw attention, when we say one paragraph, these are the 2 issues. Of course, we don't say there the issue of profit is an issue, but it is part of the issue under interpretation, which we then flesh out also in the founding affidavit from page 22, paragraph 54, 55 on.
Thank you, Justice Majid.
Justice Majid, may I just follow up on that aspect?
Sure.
Do you accept that the SCA decided the question of neutrality? And
No. We accept that what the Supreme Court of Appeal decided was the issue before it. And the issue before it was whether the introduction of the Petroleum Pipelines Act had the effect, and this was the argument or the case that Transnet, in reduced to very simple terms, had run, was that because of that statute, this agreement was ineffective. And the SCA said, no, what's happened is that the PPA sets an upper tariff limit, but it leaves Transnet able to give a discount below it. I'm glad you raised that, because it's not right to contend that by virtue of Justice Lewis's judgment, which we have to accept as final, even if Transnet has other views on it, but that judgment does not dispose of the issue in this case. It was not answering the questions in this case, as one can see from its terms and what we have argued here.
It goes back to the question that was asked by my sister. Before us, you said there are 2 issues, the special defense and the termination defense. Yes. Nothing about the neutrality issue.
No, well, the neutrality I raised purely as a matter of history, and by saying that this court has to interpret a single contractual scheme as a result of the variation agreement, because it varies the neutrality agreement. And then the question is, how can you terminate? Justice Lewis and her colleagues were not deciding the issue and the interpretation problems as outlined by Justice Madlanga and Justice Rogers. Now,
thank you.
Sorry,
Thank you, Justice Majid.
Thank you, Mr. Gauntlet. I'm not sure, would you like to add anything on this aspect? Because I'd like, just finally on my part, to move to something else,
yes,
which also concerns relevance and where there's probably before us. Are you done with this topic?
Yes, I think I'm done with it. It's subject to this, Justice Majid, if you'd allow me just to summarize. So we're saying that there are multiple references to the fact that there were profits, transport profits, which were being earned. It was pleaded, it was covered by evidence. There is nothing off the table about that. And as regards Justice Theron's question, it goes very much to the circumstances in which the 91 agreement was concluded, and points to the fact, through Mr. Crowley's evidence too, that Transnet was in that situation where it had identified this, and that the parties were unable to find, since 1967, a simple, agreed, enforceable mechanism. So that is why 91 came about. We say it's relevant in that context. And thank you very much, Justice Majid.
Yes, thank you. Thank you. Just one final aspect from my side is, again, I know you've pleaded that you cannot continue with the contract on the basis as before because of certain public law duties. But is that wide enough to encompass this public policy argument on sections 195 and 217, quite apart from the fact whether they apply? But yes, is that wide enough to cover those two grounds? Because you know your colleagues say on the other side that this is new and this it's not permissible, that we should sit on it and decide on it as a court of first and last instance.
Yes, yes. May I say this? Well, I'm trying to. Excuse me, Justice Majid. I'm trying to find the place in my notes, which are, of course.
Yes, I'm sorry, Mr. Gonda. I'm jumping around a bit, but those are the two aspects that's bothering me. Thank you.
No, I'm very grateful, Justice Majid. Always better to deal with it. May I just say this overall? First of all, what was pleaded, let's start with that, is in volume 3, paragraph 237 by our predecessors. Our colleagues rightly say that the trouble with new teams is that they either have new eyes or perhaps they don't quite say it, new imaginations. But if we look simply with objective eyes, this is what's pleaded. That we say there simply that Transnet didn't have the right to cancel. If that is found, then in that event, Transnet avers that the agreement is contrary to public policy, inasmuch as it would continue to run indefinitely, and the agreement would in that event be invalid and unenforceable. May I say immediately that what would have been desirable for any of us practicing at the time we practice is to have used the language which Justice Ngobo used in Barkhuizen, where Justice Ngobo effectively said we must wise up to the fact that boni mores and public policy now mean constitutional values. He drew that straight line equation. The pleader here could and should have said that. The question is, what is the result of the failure to do that? We submit that there is that automatic equation as a matter of principle. And that secondly, the values which are being invoked are actually pleaded fairly specifically. And that is that it would continue to run indefinitely and that the legal consequence would be invalidity. We say that nobody has been surprised, because when we come to this court, we say, because we must go through the hoops that we must go, one of the questions we have to ask answer, is there a constitutional issue? And we say that there is, because if there is an agreement which is contrary to constitutional values as a result of Barkhuizen, that is a constitutional issue. The question then is the other side prejudiced? Have they been blindsided? Is there any other way they could have conducted the case or would conduct it now before you? We say clearly not. They know what the problem is. And the problem is that we say for an organ of state, and perhaps I should say this, Justices, we're not here asking for a single answer for all time in relation to all cases. The answer that we contend here is that this agreement ends up, to the extent it can be interpreted, as having an evergreen consequence. And that for an organ of state is anathema, because then you have the situation that it acquires, well, those who do business with it acquire an immunity against procurement and procurement's requirements, and the values of transparency, efficiency, economy go out of the window, because they can say, aren't we lucky? We've got a 1967 agreement. It's simply been varied in 1991. It carries on forever. And we say that issue is always, in one form or the other, well, has always been before court. And if we've tried to sharpen up the language, well, then we plead guilty. But nobody has been ambushed, we submit, by this. It's always been understood. And that would be our answer to that.
And I know that I said as my last question, but just while you raise that, can I just ask lastly, if it's in the interest of justice to hear this matter, if on the basis that it doesn't transcend the narrow interests of your client and of Sasol and Total.
Yes.
How does it go beyond the interests of the commercial interests of the parties here? I know you understand the public policy issue, but just on this point.
Yes, we would say in several respects. First of all, inherently, because it entails determining that an organ of state in this position is felicitously freed, and those who do business with it are not bound by the constraints of the efficiency, openness, transparency. They can send each other little 2-page letters which determine the use of what was a massive national asset, and it's conducted now by an organ of state. That's inherent. Secondly, we know that it has and must have very large financial repercussions. But thirdly, Justice Majid, those are not confined merely to the parties, one of which is an organ of state. So these are not two corner shops negotiating, but it's also in the end affects the public, because we know that in the end, these transportation costs have an impact, are recovered at the pump. So those are what I would immediately answer to you. There may be better in other answers which occur, but But may I, Justice Madlanga, with the permission of you and the other justices, use this opportunity now to seek to draw together the threads of what we're saying in a nutshell on the merits issue, which feed back into the determination of whether appeal should be given. But then, because Justice Majid has been taking me to the substantial list of reasons which are offered by the other side as to why no leave to appeal should be given. I know it's been a bit backwards.
Mr. Gauntlet, I'm sorry. Before you move on to, I'm really sorry. I'm not sure. Can you explain why you say section 217 has application? We know we're dealing with an organ of state, but section 217 relates to contracts for goods and services.
Yes, yes. May I say that we take as our springboard in that regard the judgment in the AXA Imperial Fund AXA Imperial case. And let me just quickly take you there and not repeat it, but lift out what I hope is an adequate answer to justice. Sorry. Yeah, it's in paragraph 35. Now, the short answer, Justice Theron, is it was held by the Constitutional Court that one mustn't be misled by the word procurement, by the SCA, sorry, by procurement, and go to a dictionary, and procurement means to get. What is intended by the Act is effectively the two-way street, and by the Constitution, a two-way street rather, by the Constitution, two-way street as regards the providing and getting of goods and services. Let me illustrate it with the facts there. There, AXA had what in technical terms in South Africa are universally known as hokkies, those car hire little offices at airports. And the question was whether 217 applied to others who were going to rent these, like Imperial cars, from them. And the answer given in both judgments, majority and minority, is that yes, it must be so. And why is that? Because 217 is interested in achieving efficiency, transparency, in avoiding waste, and it would never want.
I'm sorry to interrupt you, but isn't the distinction that in AXA, nevertheless, goods were being procured? Are there goods or services being procured in this matter?
Yeah, the services. I mean, what was actually going on here, and it takes me a little ahead when I deal with the enrichment thing. What we've effectively got here is a contract of carriage in the old language, that oil products are being carried up one end to Natref, the crude, by Transnet, and the refined products taken the other direction.
So it's a contract to use the pipeline.
To provide a service. The pipeline is being provided. Transnet's providing a pipeline. It's providing services in relation to that pipeline. That pipeline has to be usable. It has to be serviced.
Wouldn't that be more akin to a lease rather than a contract for goods and services?
Well, but if one's leasing, I'm sorry, Justice Ron, but if one's leasing, one is providing goods and services. So there's our law would look at this and say, what is happening here? And in robust terms, as I say, it's the two-way traffic of the product as against the other party, Transnet, making sure that it's a good functioning pipeline. And so we would respectfully submit, first of all, that in interpreting, and this is the approach of the SCA, one should, interpreting 217, one should be interpreting it as a constitutional provision, purposively wanting to bring within its net the traffic, if you like, of goods and services. Here there definitely was a traffic of goods and services. And it's not...
Has Transnet obtained the use of any goods or services?
No, Transnet, and that's exactly the point. Transnet has provided it. And we stake our case on 217 that it is not the intention of 217 to confine it to when services are provided by the state. In fact, the converse is almost invariably true. But it's a two-way street. It's the commercial usage of state assets on the one hand, or expenditure by the state in acquiring goods or services on the other. So we respectfully submit that the attempt to foreclose on our argument by saying that 217 has a narrow application is one that we would ask the court very roundly to reject and to support the approach which was adopted by the majority and minority in AXA. Now, with your leave, Justice Madlanga, if I might.
Mr. Gauntlet,
Yes.
really sorry. Because I'm going to take you back.
Yes.
To the debate you had with my sister Mhlanhla. Justice Mhlanhla asked you whether the neutrality issue was not determined by the SCA, and you said that the SCA dealt with something different and you moved on.
Yeah.
I didn't want to disturb the line of discussion you were having with Justice Majid, so I reserved this question. What bothers me is paragraphs 21 and 22 of the Supreme Court of Appeal judgment, where Justice Lewis deal with the neutrality issue.
Mm.
It may have been in a different context,
Yes.
but she determines it specifically.
Yeah. No, if I was understood to say that our contention is that the earlier brief 25 paragraph judgment by Justice Lewis in no way deals with the neutrality principle, that's not what I'm saying. What I am saying is that the central issue which arises in this case, which is whether the interpretation of the crucial clause in its context in 1991 has the effect contended, is not excluded or foreclosed or anticipated by that judgment. If one looks at paragraph 21, you will see there's a reference to the neutrality principle and its application. And there is, at the end of 21, there are these two lines. If the Nat refinery was situated at the coast, its shareholders would not have incurred the costs of transporting crude oil. That was what the neutrality principle was designed to avoid. And the position is no different now that the tariff is set not by NERSA, but not by Transnet, but by NERSA. That last sentence is actually the ratio in the case. And we can have no quarrel with that now. It's not the issue in this case. So
in the second, sorry, if you look at the second line of paragraph 21,
Yeah.
Justice says in this
Yes.
matter, if the neutrality principle were not applied, there would be no differentiation despite different circumstances.
Yes.
And then yes, and then she goes to that line that we have referred to. And then in paragraph 22, she then says the tariff set in this decision are maximum tariffs, thus permitting the increase, the licensee to discount.
Yeah.
What is the effect of what the SCA is saying here on the neutrality principle?
There is no effect on the argument or outcome of this case, because as I endeavored to argue earlier, what the court then held there was that NERSA sets maximum tariffs. That's all it does. It does not prohibit or prevent Transnet as the licensee from charging less. And what had been argued on behalf of Transnet is that with the arrival of the Pipelines Act in 2005 or 3, I think it was instituted a couple of years later, was that had knocked sideways the neutrality agreement. And she's saying, no, it doesn't. NERSA does its work. Neutrality principle can apply, and it applies through discounting. It's got nothing with respect to do with the issue that we're faced with here, which is that accepting that, putting it to one side, has no implication for the rival interpretations which are advanced in relation to clause 5. And we would ask you to hold that Justice Soka was plainly wrong when he put up as a first and conclusive answer, res judicata, that this whole issue was over, was determined.
Well, probably Justice Soka was influenced by the first, also by the first line in paragraph 21, that actually says differentiation based on sound reason does not amount to discrimination. And then the reasoning continues. But I will hold you on this. I will allow you to move to other issues.
Thank you. Yes, because we say we're not here talking about differentiation. There was an argument run that treating Caltex and BP and Shell differently amounted to discrimination. That was an argument being run by Transnet. That, as you're indicating, Justice, was eliminated by the first paragraph in 21. We say that with great respect. Justice Soka should not have been influenced or confused by the first line of paragraph 21 or whatever was being made in argument of it by the other side to say, Judge, your conclusive answer in this case is that this SCA has spoken on this issue and there is no room for argument. May I then move on with your leave?
Mr. Contlet,
Justice.
Sorry to interrupt your argument. The High Court held that there is a termination clause.
Yes.
And Transnet could terminate.
Yes.
Now you are saying there may be a termination clause, but if you look at the variation agreement, they're subject to the suspensive condition in that clause makes it difficult for Transnet to terminate. Was that argument advanced before the High Court?
More than that, it was pleaded, Justice. May I find it for you?
Please.
Whilst you are looking for that, Mr. Contlet, the 1 hour is up.
Yes.
Please indicate how much more time you want.
I think I'm going to need 15 to 20 minutes, Justice.
I'll give you 20.
Not allowing, of course, for that being consumed.
Injury time.
Thank you very much, Justice. Yes. What are we referring to is page 237, where we, in that paragraph I've referred to, made the point that I believe is the answer to Justice, if I understand the question. And at 236, we say specifically, paragraph 16, that on a proper construction, the words subject to do not constitute a suspensive condition properly called in law. But the question of Justice Mhlantla brings me to what I've been endeavoring to get to, and I still have one step to get there. And that is, why do we say that the points raised against us relating to this not being a good case to give leave to appeal are bad? The outstanding hurdle is I've said nothing, and I'd like to deal with that with at core, the enrichment part of the case is. Could I put it as simply as we can, about which we are either we submit right or we are wrong? It was contended, as you know, by our predecessors in the matter, initially in the High Court, that the problem with the way it had been pleaded, the contractual case, was that there had been no cancellation of the agreement. That was plainly not right with respect, and it's not an argument which has been persisted in. But what was pleaded to was what was required as regards enrichment. And it was plainly our case that the case for enrichment had not been made out. May I just say simply why? It's contended by the other side that of course they can claim what they claim by virtue, in contract and by virtue of breach. And their answer is this, that they overpaid because they were over-invoiced. Over-invoicing is a breach of the agreement. We respectfully submit that it's not, that the whole aspect of recovering that which is an overpayment is not an action or a remedy. It is not a resort in contract to recovering it on the grounds of a breach. What one is saying is that I paid too much, and we're saying that what the law states, and the law is thin, we admit that, but nobody challenges with the analysis that we've given by Professor Sonicus, in which we reference in our heads of argument at page, in footnote 205. And it's and 207. It's simply stated this, that if you pay too much, you are paying too much, not because the other side has breached its agreement with you. You're paying too much, and you can only recover then, says the law, if you can show, depending on whether it's the condictio sine causa or condictio indebiti, which you can show a number of things. Classically, for the condictio indebiti, you've got to show that you've been impoverished. So if I, for example, have been billed for 15 when I should have been billed for 10, it doesn't follow that I can recover the 5, says the law, in certain circumstances. And what are they? If in paying the 5, first of all, the additional 5, I wasn't impoverished because the value of what I got was actually 20. That's an end to me. If on the other hand, I paid the other 5 because I was foolish, I don't get it back either. So the law is conservative in relation to issues of overpayment. This we've set out more fully, and I'm not going to belabor it because I'm into injury time in our heads of argument. But if we're correct that what was before the court at all times was the fact that, unfortunately, the neutrality principle was not preventing a situation of profit-making by the commercial oil companies, then the situation which arose is that if they at any time overpaid us, they would have to show that what they got, what they had overpaid, the 5, could not be shown to have, it could be shown to be an enrichment of us. That secondly, that they had not made a foolish error in that regard.
Mr. Gauntlet, can I just, I accept that analysis if you are dealing with a case where a contract as a whole is invalid. But if a contract is valid, to take your example of the 10 and the 15,
yes,
if I'm entitled to get something for a contractual price of 10,
yes,
but I happen to pay you 15
yes,
by mistake,
yes.
The mistake point is different, but on enrichment and impoverishment, you can't say, well, you must now show that what you got was not worth 15 because I have a contractual right to have it at 10. Yeah. So my impoverishment arises from the fact that I've paid 15, where contractually I was entitled to get the service or the goods for 10. Yeah. So I don't think there can be any difficulty with the impoverishment and enrichment requirement, can there?
No, I think on what the way you put it in that context, Justice Rogers, yes, clearly. The concern here is that there is a studious attempt to get round compliance with with enrichment requirements, though by pleading in contract. And the argument is made as fully as we can in the heads of argument, and I'm not going to add anything further to it now. May I then turn to what I think?
And why do we have jurisdiction on that aspect, Mr. Conrad?
Well, it was for these reasons that you have a situation where the main issue as we have presented it is before court on our argument. This is a related issue. It arises with it. It concerns a very large sum of money. And we respectfully submit that in these circumstances, it is something of a fenter trailer on another vehicle. And if the court is dealing with the other vehicle, then there may be circumstances in the interests of justice where the court would not say that we knock out this other issue. It arises in the same litigation, and it will determine the future course of that litigation, because justices, make no mistake, contrary to what has been suggested, the litigation continues in the court below. There's not simply an awaiting of, there's an awaiting of judgment in this matter in terms of case management, but there are issues which remain to be determined in recent amendments. So we respectfully submit that it's really up to the court, but on the fenter aspect, it would bring finality and clarity in an important respect and prevent it from coming back to the court in some other form at some future date.
Must I understand that to mean in and of itself, assuming that the fenter trailer were to be decoupled of its own, it wouldn't be, it wouldn't engage our jurisdiction, and it does so purely because the two are coupled.
Yeah.
The trailer and the vehicle.
Yeah. All right. No, we wouldn't say that because of this. First of all, if you look at volume 1, page 38, the last two lines, this issue was squarely before the High Court. Number one. Number two, it raises important questions of law. Number three, if you look at page 314 of the record, which is volume, I've lost the volume number, 3, I think it is. Anyway, 4, first paragraph, you will see that it is debated between the parties there. And we would respectfully submit that in those circumstances, the court would not decouple the fenter trailer and give it a large push into the into the area of future determination.
So wasn't buying under the contract.
Yes.
That's not what it intended to do.
Yes.
I don't think it was buying the contract.
Yeah. And you will see at page 314, paragraph 1, that the very important Sassel stance, where Sassel contends, and this goes back to something touching what Justice Rogers raised, that Sassel contends there that it was under the mistaken belief that it could not rely on the terms of the agreement, etc. And it actually then located what it was doing exactly in that context. But justices, I'm now grievously over the limits which have been set to me, and I do need to sweep up in relation to the appealability issues. And here I wish to confine what I'm going to say to a response to the points which is thrown at us by the other side in their heads of argument. First of all, they contend that the constitutional issue was not reflected in the pleadings, and there's a new issue on appeal. I partly answered that by saying public values, public policy equals constitutional values, and it's raised. It's true that 217 and 195 were not specifically pleaded, but we invite you to look at what is said by the court in Jiba in paragraphs 13 and 14.2, where the question is whether substantively the issue, the true substance of the claim has been raised. You don't have to do a Roman law incantation mentioning the numbers, etc., of the provisions. If the point is advanced so people, the defendants, can know what they are dealing with and the court itself can know. Everfresh, then the contention, which is the reliance on Everfresh, is we respectfully submit contrary to the other side. Why? Because in Everfresh, the important consideration was whether Everfresh's defense has changed to the prejudice of an opposing litigant. We say it hasn't changed, and that in the circumstances there is no prejudice. They say it's tip-top. It's not against public values, constitutional values, anything that you would say to the converse. So we would say it's like your recent judgment in Mediclinic in paragraph 9 and paragraph 38, where there is a point of law. It's pleaded, and where leave was granted by you in the Mediclinic case. May I then, and equally as regards the application of the principle to pleading, we say that it's apparent that what we've relied on in the end concerns section 217, because it entails the issue of a contract for goods and services. We say the provision of services by the state, and on AXA, we say that it covers it. And we remind you also that in Beto Star, in paragraph 27, it was held again there that it's not necessary to specify a particular provision if it is apparent enough what the objection or the complaint is. And here, nothing could have been clearer than the fact that we were relying on contracting for services by an organ of state. On the termination clause and the attempt to exclude it and the reliance on Tikkie Dry, we would respectfully suggest that Tikkie Dry, together with the University of Johannesburg, are against the other side, because in this case, as in UJ, you would otherwise have a case of a single High Court judge conclusively and in perpetuity, if I may use the phrase, having determined the issue without appeal. And in Tikkie Dry, this court held that the chief arguments were radically different. We say they're not radically different, and it goes back to the substance, the substantive point in Jiba. It's a matter of characterization. And Tikkie Dry, the questions were not before the High Court. We say that they were in this matter, and that is the point of distinction. And then on the interests of justice, may we simply say this, that in our heads, in our section C5, we give the three grounds why we say the interests of justice are met. But looked at more fully in terms of the heads, we ask you to consider that you have a contractual regime predating the Constitution of the most skeletal and problematic nature, in effect since 1967, and with an impact inevitably on transport costs. We say that if you hold that it's wrong that 217 is being considered for the first time in this court, because it's not. It was referred to in the judgment, for instance, in the court below. Yeah, and the important point is that 217 comes not naked to this court without determination by other courts. There's been a plethora of decisions dealing with section 217 since Justice Marais in the Supreme Court of Appeal in contract props almost 20 years ago, completely ventilated, and more recently in AXA versus Imperial Group, as the exchange with Justice Turon also pointed up. So this court has not been precluded or not been deprived of that. And as regards also the question of interests of justice, we also would draw your attention to Clicks Retailers, Justice Turon's very recent judgment. Clicks, not new Clicks, Clicks Retailers versus Commissioner for SARS, regarding general public importance and reasonable prospects of success. One last point, we've shown you the fact that on the papers, there is a reference to the genesis of the relationship between the then government through the Department of the Railway, South African Transport Services, Total, and Sasol, also then in government form. There is this outrage that there has been reference to the context in which we have cast it. This court has repeatedly, relying no doubt on cases which go back a long way, like Consolidated Diamond Mines of Southwest Africa, 1958, 4572 at 610A, dealing with, in that case, the history of German occupation in Namibia. But this court too, in Gavrik versus Refugee Status Determination Officer 2019, 121 at paragraphs 87 to 88, has had regard to a historical, political, sociological character, as it's done in other cases like Mazabuko for a long while. The short context in the end is that there was a cryptic agreement in 1967 to serve strategic aims which try to capture a principle. The principle has been hugely problematic. It generated the variation agreement in 1991. And what was contemplated then was a capacity of parties to escape. The answer which the High Court has given is that the escape is achieved by climbing into another sealed capsule, and you, in those circumstances, lose the contractual right accorded in 1991 to be able to terminate it. You had it once, that was the good news. The bad news is you've got to climb into another relationship if the contract in clause 5 is capable of being given a meaning. Thank you, Justices, for your forbearance, for which I'm partly responsible, but will not accept full responsibility in running over.
Justice Madlanga, with your leave, if I may put one more question to Mr. Gauntlet. Mr. Gauntlet, do you have any authority for the proposition that claims for repayment or overpayment, where this overpayment is to have occurred in the context of a contract or breach of contract, must be brought as an enrichment action?
Yes, it is the source to which we drew attention. It's Professor Sonicus's analysis. If by Justice Turon smiles, if by that you mean, do I have other case law? No, I don't.
I mean case authority, yes.
Yes, no, yes, that is the answer. So it's either right in principle or it is not right in principle. Thank you.
Thank you, Mr. Gauntlet. Thank you, Justice Madlanga.
I may say just that there was no response, no challenge to the goodness of that in our colleague's argument, but that's another point. You might hold that two wrongs don't make a right. Thank you, Justice Turon.
I thought my brother, Justice Madondo, wants to ask a question.
Yes, thank you, Justice Madlanga. Mr. Gauntlet, where is he now?
Is there?
The first thing here is there. Oh, I see him now. What is meant by the full agreement in this matter?
Well, that is exactly one of the conundrums we drew attention to, Justice Madondo. And what it's saying is, in contrast with what we have now, when we're talking about at the time of the exchange of POC and 3 and POC 4, which is not the full agreement. There should be a full agreement. Now, it then, as Justice Soka says, it means that it's an unagreed agreement because it's an agreement prepared by one side, which has to be sent to the other side. And the other qualification is it must be full. So it can't be another back of the envelope or 2 or 3 letters. But how full is full? And how is that consummated? These are the problems which I think we've debated. And I'm not sure I can usefully add any more to the 3 interpretations and Justice Rogers' 4th, which arise from that.
So what are the essentials of the full agreement in this regard?
We have no idea. And that's the point that I made earlier, Justice Madondo. And that is that for the other side, they may say there's no full agreement unless there's an acceleration clause, unless there's an arbitration clause, unless there's this, that, or the other. I could have thought, and even somebody else might think, it's a pretty full agreement. But there's never a full agreement until there's an agreement. And there's only an agreement when it's agreed.
Okay. How does the neutrality principle implicate section 217 of the Constitution?
Because what you always have to do is apply, if you're an organ of state, and if it falls within the net of the two-way street, as we've described it, as we understand AXA Imperial, then you've always got to have regard to efficiencies, economies, transparency, and the like, and competitiveness more than anything else. Here you have a deal. You have a deal struck between the government at that time and what has mutated from it as one oil company and another oil company. No involvement of the excluded oil companies. And so in those circumstances, having that which seeks to achieve an agreement which involves none of the other openness and opportunities for the others creates a problem.
Okay. Thank you, Mr. Conlett, and thank you, Justice Madlanga.
Thank you, Justice Madondo.
Thank you, Mr. Gauntlet. The court will adjourn and let's resume at 11:44. Court adjourn.
Thank you.
Court will adjourn until 11:44. Please note that during the adjournment, you are welcome to switch off your video and mute your microphone, and then rejoin with the video and sound when the hearing recommences at 11:44. Should you exit, you may use the same link to rejoin the hearing.
Ms. Aplani, please do let us know once everybody is in.
Justice Madlanga and justices, all councils are online.
And all my colleagues as well.
Yes, only except for Justice Majid.
There's Justice Majid. Thank you very much. Yes, Mr. Bam.
Justices, I want to start and spend my first few minutes just tracing through chronologically what has happened in this case and what its response at Origo is.
Colleagues, please remember, Mr. Bam said we can interrupt him right from the start.
Thank you. The starting point, of course, is the very agreement which we're fighting about, and that's the variation agreement. And the one person who did testify contextually to that was Crowley, and I'm going to go through certain passages in his testimony, but I want to start at a slightly different point. If you look at the variation agreement, and that's at volume 2, page 130, it starts off.
Just a matter of courtesy, Mr. Bam. Some of us prefer that you should use people's titles. If it's a Mr., Mr., if it's a doctor, doctor, please, instead of just saying Crowley, please.
I appreciate that. My apologies.
Thank you. Thank you.
If you start off with the agreement itself, it immediately tells you what it is dealing with. Much has been made about a 2-page agreement, but let's go to what fundamentally it deals with, and that is, you'll see that from the introductory portions of page 130, where it says that question to discussions pertaining to the tariff applicable to the transport of crude oil. So the first thing is it dealt with tariff. The second thing is in relation to the transportation of crude oil through the pipeline. And it then says that it relates to the tariff increase, the continuation of service, and the use of services offered. Paragraph 1 then sets out the formula for percentage increases in the crude oil tariff. So as a starting point, when this litigation started, it was about Total. Cecil came in at a later stage. Total come into court and saying that what we are being charged is in contravention, in other words, in breach of paragraph 1 of that agreement. The first issue that arose, because the issues we're dealing with now came up after the SCA judgment. The first issue that arose is having regard to the changed legal landscape, namely the introduction of the Petroleum Pipelines Act. Did that impact on the existence of, the legal existence of, or the continued implementation of the Pipelines Act? Now that's quite important, and my learned friend, Mr. Gauntlet, when he deals with the SCA judgment, with respect, underplays its significance to the issues that we're dealing with now, or to the issues before this court. Because at the outset, to the extent that there was a matter of general public importance, it would have been whether a tariff regulating agreement between Transnet on the one hand and the Netref shareholders on the other hand was impacted upon because of the introduction of certain pieces of legislation post its commencement. Now, before I go into that SCA judgment, let's just go into the relevant legislation, because that should put paid immediately to any references to section 217 and 195. That legislation is the Petroleum Pipelines Act 60 of 2003. And there are provisions of there which are quite interesting for the present debate as well, because it will illustrate, even in the interpretation of clause 5 and the argument against clause 5, why the applicants are wrong. Starting point for that is that to operate a petroleum pipeline, you need a license, and that's in section 15. What's of significance is what's set out in section 20 of that act. That's the conditions of license. The authority may impose license conditions within the following framework. I'm going to read to you 3 of the subparagraphs. Subparagraph C, to provide for an appropriate supply of petroleum products to meet market requirements. Now, those are market requirements wherever they may be situated. Paragraph F, though, would interest you because it says that the petroleum pipeline may be licensed for either crude oil or petroleum products. And there already there's the distinction between what is transported to NETREF, which is the subject matter of the variation agreement, and what is transported to its competitors. The only place and the only use of the pipeline for crude oil is to NETREF. So it says, or both, as long as sufficient pipeline capacity is available for crude oil, and this part is quite important, as long as sufficient pipeline capacity is available for crude oil to enable the uninterrupted operation of the crude oil refinery located at Sasolburg. That's NETREF. In other words, in enacting the Petroleum Pipelines Act in 2003, the legislature gave specific recognition to the significance of the refinery at NETREF, because it provided that the pipeline must always have sufficient capacity for that. There's then the provision of access to the pipeline for whoever wants it, and that's in paragraph G. Just pause there for the time being. There is a statutory obligation in terms of a specific statute dealing with the pipeline to make capacity available for whoever wants to use the pipeline. But in addition to that, there is recognition and a statutory injunction to ensure that the needs of the inland refinery at Sasolburg, i.e. NETREF, are catered for. But clause 21, or section 21 then says, licensees may not discriminate between customers or classes of customers regarding access, tariffs, etc., except for objectively identifiable and justifiable grounds. And that's something which the SCA spoke to. And finally, in section 28, the Act deals with the setting and approval of tariffs. Inter alia, they're required to be fair and non-discriminatory. So what went to the SCA was the question of whether or not this agreement dealing with a percentage increase which would keep the tariff for the transportation of crude oil lower than the tariff for the transportation of white fuels, which is what Sasol and Total's competitors were transporting, whether it could be enforced in light of the new regime. The simple point is the legality and public interest in relation to the agreement arose at that particular point in time, and the SCA dealt with it. Justice Theron made reference to a couple of paragraphs in that judgment, so did Justice Mhlahla. And if one goes to that, it's in the record, volume 1, page 72. In a judgment given by the SCA, which everybody accepts, the parties are bound by, it's in this case, and in respect of which this court had refused leave to appeal because there were no reasonable prospects of success. The court dealt at paginated page 74 of the bundle, volume 1, paragraphs 17, 18, and 19. The court deals with the arguments in relation to the PPA. And at paragraph 17, the court captures it as such. The nub of Transnet's argument on appeal is that the neutrality principle cannot coexist with section 28.6. Only NERSA may set a tariff. Now, what the neutrality principle was, and it's quite important to know that, was a principle which ensured that neither Sasol nor Total would be at a disadvantage vis-a-vis their competitors on account of them transporting through the pipeline crude oil to the inland refinery, which then had to be refined, whilst their competitors were using a coastal refinery and transporting white fuels, petroleum products. The court then goes on in paragraph 21 to say that differentiation based on sound reason does not amount to discrimination. And then at at paragraph 23, at the top of page 75, it says that if the formula provided for in the variation agreement was not applied, it would amount to unfair discrimination, which puts the NetRef shareholder at a disadvantage. Now, that's been determined already. Why is it that significant? Because the court recognized that the circumstance which gave rise to the neutrality principle being embodied, arising, was to ensure that neither Cecil nor Total, as against their competitors, were at a disadvantage because they would otherwise have ended up paying for higher transport costs. Higher transport costs, because if they transported 100 liters of crude oil and paid exactly per liter the same price as their competitors paid for 100 liters of white fuel, by the time that 100 liters of crude oil inland was refined, it would have been reduced, whether to 90 or 91 liters, or whatever the case may be, but the effective transportation costs would have increased. And so your starting point when you look at this agreement on an issue which was placed before Justice Soka and disputed by Transnet, but is no longer before this court, is that the underlying purpose, the context, to use the language of this court in UJ, was to ensure that there would be no discrimination unfairly against Cecil and Total on account of the use of the pipeline for transportation costs in relation to crude oil. That's the fons et origo, and that's the first principle that needs to be understood. Once you appreciate that, you then understand when and how the 3 points that were before Justice Soka had arisen. The first was the interpretational issue. Dissatisfied with what the SCA had found in relation to the applicability of the agreement, Transnet then introduced an interpretational issue which included questions such as locational advantage, excess profits, and the like. All of that was embedded in the first issue, the interpretational issue, which is no longer before this court. That issue is not before the court. And the fact that there may have been allegations made in pleadings, which is all that Transnet now refers to when it talks about profits and the like, doesn't make that evidence. That is a pleading. It's not evidence, and it's a pleading on an issue which is arisen, which you've been pointed to, which comes in the rejoinder, way down the line in the scheme of the pleadings. The other two issues, the special defense, and I should read to you the special defense as it is pleaded vis-a-vis Total. But the special defense, namely whether you're forced to go the enrichment route, was introduced after the SCA judgment. Similarly, the termination defense arose as a result of the termination letter, which came up after the SCA judgment. Now, let's just see what they say in relation to the special defense. You will find that vis-a-vis Total in volume 3 at page 215, paragraphs 1D and 1E. What you're now told vis-a-vis Total is that Total was obliged to plead an enrichment claim. As a starting point, we will submit to you that that is wrong, but let's see what the pleading vis-a-vis Total continues to say. It says that the recognized remedies in law for a breach of contract do not afford the plaintiff a right to recover monies that it alleges it overpaid, absent a cancellation of the contract. The plaintiff does not allege that it canceled the contract. Of course, it can never run that argument. It fell flat at an early stage. But their point on their pleadings against Total is that you were obliged to cancel the contract before you could claim that which you are claiming. And all Total claimed was to be placed in the same position it would have been in had it not been overcharged. Whilst I'm in that volume, may I take you to page 237, because this comes up and is relied upon by my Paulin friend, Mr. Gauntlet. This is in relation to the public policy issue. I don't understand the jurisprudence of this court to suggest that you can say something in wide terms without elaborating upon it to identify the issue to be sufficient. And what they plead is that in that event, Total averse. So it says, if it is found that Transnet did not have a right to cancel the agreement on reasonable notice, that whether it was entitled to do so or not is a question of interpretation. It says then, in that event, the Transnet averse that the agreement is contrary to public policy, in as much as it would continue to run indefinitely. So their argument was,
this is volume?
Volume 3, page 237. You'll find it in their plea. So it's the same volume I was in, where, so just look at what they plead in relation to public policy in the context of the termination defense. They said, first of all, on an interpretation, it was terminable on reasonable notice. But if it's not terminable on reasonable notice, it's contrary to public policy. And my own friend, Mr. Gauntlet, keeps saying that's wide enough to encapsulate anything, including sections 217 and 195. But that's not the way they framed it, because they say, in as much as it would continue to run indefinitely. So the concern that they raise is the following. Because it would continue to run indefinitely, ergo, it's contrary to public policy. Now, again, that's stating a proposition without regard to the content of the agreement and the context within which that was concluded, without regard to what the Pipelines Act says, without regard to what the SCA have to say. Namely,
Mr. Pam, are they not saying as an organ of state, Transnet is unable, due to this type of contract or this clause 5, it is unable to get out of this contract? And it's tied up in perpetuity. And there are cost implications involved to that.
I'm going to address that point right now, because that's what I was getting onto next, Justice. The point is simply this. First of all, you can't deal with the question of in perpetuity, tied into it forever, or evergreen, or the type of statements they make in the heads of argument, without understanding what the agreement is and what its context is. And then you've got to ask yourself, has that context changed? This was dealt with by the SCA. Because if it hasn't changed, you've got to ask yourself the next question. If the context remains the same, what would be the effect of the tariff dealt with in paragraph 1 of the variation agreement at page 30, volume 2, 130, volume 2, is not applied? The answer is also given by the SCA. The point is this here. For so long as the circumstance giving rise to the principle of neutrality and the variation agreement exists, why is it per se offensive to ensure through the regulation of a tariff discount as is set out at page 130, paragraph 1, its implementation? Because if you don't implement it, as per the SCA finding, endorsed by this court, you would be unfairly discriminating against Total and Cecil. So the point is simply this. If you were to take, they say an organ of state, but of course, I've taken you through the PPA. The PPA obliges them to give capacity for Cecil through the pipeline for the transportation of crude oil. The PPA requires it to be non-discriminatory and fair. And the SCA dealt with the question of the position you would be in if you did not apply paragraph 1 of the variation agreement. It would be unfair discrimination and disadvantageous in a manner not permitted by the PPA to Total and to Cecil. Not the other way around, as is contended for now in loose terms without any evidence about the other oil companies. Now, against that background, you then look at the opening shot of the applicant in its heads of argument, because you'll see there already how misconceived this case is and why this court should not entertain it. The following is stated. I'm going to read this. And remember, this was retained even after the ruling, the Rule 20 ruling. It says, should Transnet be permitted to terminate? And now comes the language which doesn't assist, because it doesn't get into the type of legal exercise we meant to undertake. To terminate a stopgap 2-page agreement concluded in 1991. And then it says, almost rhetorically, the way it's framed, or should it be forced? Well, it's not being forced because there's been a finding on it already. Notwithstanding fundamental changes in the political and legal landscape since 91. Let's just pause there. The change in the legal landscape, which is all that we're interested in, is one which was dealt with by the SCA. And in relation to NETREF, is specifically recognized in Section 20 of the PPA. It says to perennially subsidize at public prejudice. Well, that's just wrong, because there's no evidence to justify that. In fact, they're not subsidizing anybody. They're ensuring that they give effect to the provisions of the PPA. It says two commercial enterprises profiteering already for decades from a technical petroleum. And when you're told of profiteering, you constantly heard the figure by 20 million a year. Well, there are two things in relation to that. The first is the reference that was made was not to any evidence before the court. It was to an annexure to the rejoinder. Now, an annexure to the rejoinder is not evidence per se. The second point is, even in that reference, you are given half the story. So I'm going to take you to that. It's completely irrelevant, but it's been given to you, but not completely. It's at page 262 of the papers. That's volume 3. So if you go there, you'll see just below the table at line 10. Sorry, page 263 at volume 3. Just below the table at line 10. It is apparent from the above. So this is an email from Total to CESO. So it says, it is apparent from the above that the additional amount recovered amounts to an average 20 million per annum. Now that's the figure you were given as an undue profit which they're reveling in. It's just not what this says. It says the recovery for 2002 and 2003 is skewed because less NETREF product was sold owing to the refinery fire. Now look at what it goes on to say. While a superficial examination of the above figures may yield the conclusion that NETREF does indeed receive income to which it is not entitled. And the sentence starts, a superficial examination. Such a conclusion does not take into account the fact that NETREF has a significantly higher yield than coastal refineries. Compared to a Durban average of some 68%, NETREF has a white product yield of 91% and a total yield in excess of 100%. This extraordinary high yield can be attributed to two factors: the investment that NETREF has made in additional refining capacity, as well as the importation of external energy to increase efficiencies. Now, and then it goes on to talk with the investments and the time it would take to recover the yield. So simply looking at 20 million, when that's a result of NETREF having in its refining process increased its efficiencies because of a substantial capital expenditure, tells you that these statements about profiteering, it's just got no basis in the evidence, and a reference to a passage in a rejoinder doesn't help one, but it's not evidence. And even to the extent that you read the very document that you've been taken to, is just wrong, because that document tells a fuller story if you just read it more extensively. So I've told you what the agreement itself says. You might find, and this has been included in the record, if I can just find my volume, the evidence of Mr. Crowley. And you'll find that at volume 6, supplementary volume 6, and it starts off at page 425. The one thing that will strike you, so that we don't get carried away with what can be referred to and what can't be referred to, is that what you've allowed is the transcript, and there is no anomaly, as my learned friend sought to suggest. between what the acting Chief Justice had ordered and what the ruling said. Because all that is confirmed in the evidence are the uncontested portions of Crowley, and you'll see that at page 426, page 426 of supplementary volume 6, line 10, and this is in chief when he was just introduced. It tells you which paragraphs he is confirming. Now, I'm going to give you a summation of what Crowley says under cross-examination. Mr. Crowley, my apologies, Mr. Crowley says in his evidence, and then how you get to the conclusion. What had occurred, which led to the dissatisfaction, is that the Ports Authority at that point in time increased the conveyancing rate for crude oil by 15%, as opposed to a 10% increase for white fuels. As a result of that, the gap between the rate for white fuels and the rate for the transportation of crude oil had reduced. In other words, it meant that the overhead, insofar as it related to transportation costs of crude oil, was now they were much closer. But the problem, of course, was that was precisely the disadvantage that the Netref shareholders were at, because now they would effectively end up paying more for the conveyance of their product, and they had to be faced with the fact that as a regulated product, certainly in relation to petrol, they couldn't recover that by charging more than their competitors. They were charging a fixed rate. So they had the same selling price, but a higher overhead. And all of that Mr. Crowley deals with quite comfortably. And it is in that context that you look at, and you'll see this at page 470 of the transcript, that they negotiated the variation agreement. And he says as well, two important aspects. The first that, and you'll see this if you go back to page 458, and this is quite important because every time there's a reference to profiteering and comparisons to the competitors, what is lost sight of is what Mr. Crowley himself says at 458, that in relation to transportation of product, crude oil and white product is the fuel you see at the pumps, were different products. And you see that at the top of page 458. Now, once Total and Cecil had understandably said that by narrowing the gap in the rate, you're putting us at a disadvantage vis-a-vis our competitors. They agreed to simplify matters on the formula, and the formula is such so that it doesn't prohibit them in relation to the extent of their increases. So this whole argument about at the expense of a state-owned entity is just wrong. What it does is it regulates that the gap as a result of annual increases between the rate charge for the conveyance of crude oil and the rate charge for the conveyance of white fuel would remain so as not to disadvantage Total and Cecil vis-a-vis its competitors. Now that's the context, that's the circumstance, that's the purpose of the agreement. And that takes you to another point, which you can ask, and I ask rhetorically, and I suspect I might get some questions about this, but I'd ask rhetorically. If that circumstance remains, having regard to the provisions of the PPA and having regard to the judgment of the SCA, why is there a constitutional or public policy problem? Because the implementation of the principle and the implementation of that variation agreement tariff avoids a breach of the PPA. Again, I'm not saying something that hasn't already been found by the SCA. That then takes me to the three issues. What I want to do, to the two issues. What I want to do is go into the substance of each of the two issues before you. And then
Excuse me, Mr. Ban. Mr. Bam, are you then submitting that if one were to have regard to the context and the purpose of the agreement, the fact that it is unlikely for Sasol and Total to agree to a variation of the terms of this agreement should not bother this court?
I'll come to that, but can I just say what I'm going to say in that regard? For so long, and I'll deal with 5 more fully if I could get there shortly, but can I say this, that the replacement agreement has to embody, and that's the language used here, has to embody the content of the variation agreement. Now, what's the content of the variation agreement? The content of the variation agreement is to ensure that there's a tariff for the transportation of crude oil, which does not disadvantage Sasol and Total. That is now, so that was written in 1991. That is now statutorily enjoined, and the SCA dealt with it. And you've got to say to yourself, first of all, you can't deal with issues in vacuum. So the mere fact of an ongoing obligation says nothing if it's contractual, because you've got to read each contract in its context and its purpose. To debate that point, you've got to understand the admitted purpose of this agreement, and that admitted purpose, despite what is said in paragraph 1 of our learned friends' heads of argument, is not profiteering, because there's no evidence in relation to that, and that ship has sailed. It's been dealt with by the SCA, endorsed by this court. The admitted purpose is to ensure, the admitted purpose in 91 was to ensure that it wasn't disadvantaged in the manner that I've outlined. That purpose was strengthened by the 2003 Act. That Act was considered by the SCA. The SCA said that to do otherwise, to do what Transnet suggests can be done, would impact on that Act, but not in the manner Transnet contends, in fact, in an opposite direction. And so what I say, yes, Justice Tiki, is that for so long as a circumstance requiring a particular remedy exists, then why is there a problem with the continuation of that remedy? Put differently, the debate about evergreen and in perpetuity, in a sense, takes the debate away from the real issue. Because if the circumstance change, then there are 2 issues. The first is that the basis upon which the contract was concluded, and remember the last sentence of this of the variation agreement tells you what the intent was, falls away, and so with it must go that discounted tariff. And if the circumstance changed so that the continued implementation of the tariff set out in the variation agreement would now start advantaging Sasol and Total, well, then you've got a PPA problem with that. So it would be prohibited in terms of the Act. But as things stand at the moment, not to implement it, not to continue with it, would create a problem under the PPA. And that finding has been made already. We can't go back to that. And that's why I say, I started off at an early stage to illustrate what the SCA had found in order to put to bed the suggestion of profiteering and the like. I referred to the PPA to illustrate that what was conceived in 1991 as the variation agreement now has the backing in principle of a 2003 statute, a statute in present-day South Africa. So yes, Justice Tiki, my answer to your question is, this court has enjoined us in a carefully written judgment in the University of Johannesburg case to ensure that regard is always had to context. Let's not forget that when going through this contract, including when we come to 5. Against that background, can I then go to the two points that are raised? And can I take you through how, in the revised heads of argument, the various passages and paragraphs, how Transnet frames the first point? We start off in paragraph 28. This is in the supplementary volume 8. And you'll see they start off page 667, paragraph 28. The first is the proper interpretation of the termination clause, whether an interpretation effectively rendering the variation agreement evergreen offends public policy and by extension, sections 195 and 217. Of course, the way they start off by framing it creates a problem for them. Because if 217 and 195 either are not implicated or should not be dealt with on appeal because it was not specifically raised. And I illustrated to you what that paragraph was dealing with in the rejoinder. Then their basis or their very first statement on what that issue is creates a problem for them already. Paragraph 32. Again, they talk about a contractual term being contrary to public policy is unenforceable. And can I just pause there for a moment? This court last year in Bidika stated that if you're going to raise a public policy issue, first of all, for the enforceability of a contract, you've got to identify the particular public policy. Then you've got to prove it. You bear the onus of proving that that public policy issue is offended against. Now, you won't find anywhere on the record evidence on 217 and 195. It's not even pleaded. It wasn't even thought of. So then they take it further in paragraph 35, and you'll see again, 35 and 36, they refer to 217 and 195. Go to paragraph 86, and I'm just going to give you the reference to show you how they themselves identify it in their heads of argument. Paragraph 86, they say, because Transnet is an organ of state, they're rendering a service through a significant public infrastructural investment in perpetuity is contrary to the objectives of 2171. Of course, what they don't grapple with is that, yes, the pipeline is important, crucial infrastructure, but in the very act which regulates it.
Mr. Bam, am I right? You are currently addressing the termination issue.
Yes, I'm dealing with it.
I mean, that's you're introducing that issue. In that context, can I then ask you, do you accept that the 1967 agreement, the original agreement, was not in its terms perpetual?
And can I answer the question in this sense, Justice Rogers? The question you asked me is whether it was not in the sense perpetual. In other words, was it evergreen or not evergreen as that term is being used?
Well, what I said in its own terms. In other words, there's nothing express which says that it's perpetual.
I accept that, but what I want to point out is it established a principle. And that's why you should never overlook that, which was directed towards catering for a particular circumstance and for so long as that circumstance existed.
Now, the ordinary consequence of an agreement not containing terms about its duration or termination is that it's terminable on reasonable notice. That's the law. That's the term which the law implies. And in the circumstances that prevailed in 1967, reasonable notice may have been quite a lengthy period, because if parties weren't going to have the pipeline, they might need to construct one of their own, and there would be questions of recouping the cost of the investment and so forth. So the notice might have been 10 years, it might have been 50, one doesn't need to go into it, but would you accept that it's of some significance that when the parties concluded the variation agreement in 1991, they were not dealing with, that they were not varying an agreement, an existing agreement, which was perpetual?
No, can I say this? And that's why, Justice Rogers, if I may, I want to take you to, I want to slightly change the framework of the discussion I have with you in order to answer your question, because I think the question that is asked doesn't adequately deal with the issue that the parties were confronted. Let's take the approach you adopt, namely, could they terminate on reasonable notice? Well, you then ask yourself, what was reasonable notice? And what I'm postulating is that for so long as the circumstance existed, they had to apply that tariff agreed upon. And the reason
for as long as they were in a contractual relationship, but the law implies that they can get out of a contractual relationship on reasonable notice, and what is reasonable depends on the circumstances.
But that's the point. And in that instance, what you would have considered in relation to reasonableness.
Yes, but what it does not mean, sorry, Mr. Bam, to interrupt you, what it does not mean, whether you say it's reasonable is 5 years, 10 years, or 20 years, it doesn't mean perpetual.
No.
So,
sorry, can I just, I've just been, there's a page because I was thinking about this, Annexure POC 1. And that you'll find at volume 3, page 208.
Yes.
Letter from the department. This is in 1967. In the second paragraph of that letter, in determining the tariff for the conveyance of crude petroleum by pipeline ex-Durban to Sasolburg, the principle must throughout be maintained that the total net revenue, i.e. revenue less expense, that the department will earn from the conveyance of crude petroleum ex the coast to Sasolburg and the white products, as well as other byproducts to the ultimate destinations, will be the same as what would have been earned if all products marketed by the particular project were conveyed. It then goes on to say, in view of the aforegoing, and on the basis of the information furnished by Sasol, the relative tariff has been calculated as 40 cents per 100 pounds. This tariff will be subject to periodical revision, say every 3 to 5 years, except where radical changes in any of the underlying factors, such as source of supply and marketing pattern, necessitates an earlier revision. So in its own terms, at that point in time, what they understood was that they were talking about a tariff whose underlying principle was that Sasol and Total would not be prejudiced vis-a-vis their competitors by being an inland refiner. So asking...
I'm not sure that leads to any implication that the agreement is perpetual, but let me move on from that. If one then turns to the circumstances in 1991, yes. Nobody had yet tried to terminate the 1967 agreement, but there was some unhappiness. But either way, the relationship had already existed and been governed by the neutrality principle for 24 years. So what, in terms of termination, the question of what would have been reasonable notice if it had been given in 1968, things have moved on. Parties have had the benefit to some extent of their investment for at least 24 years. Now, when clause 5 says each party shall give the other at least 3 years notice of intention to disregard the contents of the letter, if one stops there, it appears to accept, well, we'll come to the subject to clause now, but it appears to accept that in some circumstances, the being bound by this letter can be terminated on 3 years notice.
When you say that we'll come to the subject now, I'm afraid I can't.
Yes, no,
that you, you can read that without the subject to, because then I don't agree with the position put to me.
I'm not saying that. I'm putting to you that the first 2 lines of clause 5 indicate that the parties intended that there should be, in some circumstances, an ability to terminate this letter arrangement on 3 years' notice.
And what it's subject to, what those circumstances are.
Right.
Is what,
now,
sorry, can I just want to go back to a point, a comment you made a little earlier, because it's, I want to point out why it's incorrect. You said after 20, 25 years, they've already had a return on their investment. Now, that's not what the variation principle is all about, because the variation principle applies for so long as there's transportation of crude oil versus transportation of white fuels. That's what the variation, because it's a transportation cost, and that's what they're dealing with. If we can then go back into 5.
Yes, now on the subject to aspect, I'd like your response to what, after Mr. Gauntlet had given 3 possibilities, I suggested a 4th, which was I must say, my reading of the clause, which is that the first 2 lines suggest that on 3 years' notice, a party can cease to be bound by the terms of the letter. But then it says, subject to the arrangement that a full agreement of conveyance for crude is being prepared, and that such agreement will embody the contents of this letter and supersede this letter. So it appears from that present tense is being prepared that it's talking about something that was either underway at that time or expected to happen quite soon.
It was on the drawing board, to put it differently.
Yes, yes. And that the reason why that is tagged on in clause 5 is because the parties realize that if they do in fact conclude a full agreement, which they perhaps expect to do within the next number of months, then that agreement will supersede the letter. You don't then need a notice to terminate it.
Absolutely.
Yes. So if there is a full agreement, that will immediately supersede the letter and nobody needs to give notice. If there's no agreement, there's the right to terminate on 3 years' notice. All that the subject to clause is signaling is that if there is such a full agreement, it will supersede, and therefore there can be no question of having to give notice not to be bound. I appreciate that that's not your argument, but can you indicate to me why you say it's not a permissible reading of clause 5?
I'm going to do that now. Thank you, Justice. And in many senses, the question you've asked me.
And just before you respond, Mr. Baum, how much more time do you want?
I want to deal with this question because as far as
your 45 is up.
So can I deal with this question? I'm going to make. I need 4 or 5 minutes on the other part. But for me, this is the crux of the debate now. So if I can deal with this, and if we give me another.
So that means if I give you about 7 minutes, depending, of course, on questions from my colleagues, about 7 minutes then. All right.
So can I ask for 4 to 5 minutes over and above this debate here, if I might just?
No.
No.
Sorry, I'm not sure what's going on. Justice Rogers, can I now?
Please continue, Mr. Baum.
I'm continuing. Justice Rogers, can I just say this? That you put that up as a fourth possibility, and in many senses, what you ask takes us to what is a real debate, as opposed to the type of points that were raised by on behalf of Transnet. And the question that you say you raise is that if in that 3-year period there is a new concluded agreement, then of course it supersedes and ergo the letter agreement falls away in any event. But that tells you, I can't hear you, Justice Rogers.
It's not just the first 3 years. It would, if, for example, a full agreement were concluded after 5 years, there'd be no question of having to give notice to disregard the letter because the full agreement would supersede.
In other words, the conclusion of a full agreement. And that arises in any circumstance. You enter into a heads of agreement. There's another agreement that's concluded in which has things like the domicilium and an arbitration clause, etc., etc. And it says this supersedes all previous agreements between the parties on the subject matter, and in its own terms, that new agreement, the full agreement, eliminates what existed previously. But what's clear, and if you look at that, you've got to look at that together with what appears on the next page, at page 132, because that's said to be part of the agreement, and Mr. Crowley testified to that. Our understanding is that these conditions will now be incorporated in an encompassing agreement between ourselves and Petronet with respect to the transport of crude oil via the pipeline. It is our understanding Petronet will draft that agreement. That what the parties were dealing with in 5 is an anticipation that there would be, for want of a better phrase, a full agreement, something with a lot more nuances and sophistication. But the central exigible part of that agreement had to embody the neutrality principle because that's what was crucial. In other words, in relation to the neutrality principle, that had to be agreed upon.
But it didn't, can I ask you this, because I think it's important, it didn't have to embody perpetuity. In fact, it could have embodied the 3-year notice clause that is in clause 5.
That's a problem, because can I give you a formulation which I would submit to you is what the parties had intended. It would embody, and that says it would embody the contents of this letter. The contents of this letter was transportation costs for fuel oil, which would not disadvantage Sasol and Total vis-a-vis their competitors. Now,
but why do you confine the contents to that? Why can't the contents include the first 2 lines of clause 5?
It deals with the whole agreement, but of course the first 2 lines of clause 5 relates to what is going to supersede this agreement. So let's just assume this. Assume you write an agreement and you say to yourself that the very purpose of the neutrality principle is to ensure that Total and Cecil are not disadvantaged. What you're postulating to me is they can then come and say that we now conclude a new agreement, which as its at commencement will provide for a tariff which doesn't disadvantage them, but we can at any time terminate, even though on termination, they are now disadvantaged, discriminated against in the manner spoken of by the SCA. And what I'm submitting to you is that's what Flive could never have envisaged. And you can't interpret it in that way.
But I just don't understand why you confine the whole of the full agreement to the neutrality principle. An agreement contains many provisions. Clearly, it must preserve neutrality for as long as there's a contractual relationship. But a full contract you would also expect to contain terms as to duration and termination.
Let's go to the terms of the variation agreement, because it seems to me that you have difficulty with me dealing with the neutrality principle in the variation agreement, but let's go through it.
No, I have no difficulty with your dealing with it. I have difficulty with what appears to be your argument that if there was a full agreement, it should embody nothing but a neutrality principle. It couldn't contain terms as to duration.
I'm not saying that, because it can contain terms into duration, and I would suggest to you what it can. For example, you would say that should the circumstance giving rise to the neutrality principle fall away, this agreement terminates. That would fairly embody what is contained in the variation agreement. If you look at paragraphs from the start of the agreement, the introductory portion, paragraphs 1, 2, 3, and 4. 2 deals with the usage of the pipeline. The others all deal with the calculation of the percentage increase. In other words, the neutrality principle. 5 then talks about termination, but it's in the context of being replaced by an agreement which embodies the principles of this agreement. Now, what I'm saying to you is what you're postulating to me is why can't a new agreement simply have a termination provision so it can be terminated on 30 days notice, at will, whatever the case might be. And my submission to you is such a provision would not embody the principles set out in the variation agreement. It would undermine it, because it would mean that for so long as the circumstance which requires and justifies the application of the neutrality principle exists, that is what will be charged on the tariff. And I've indicated to you that now has got endorsement from the SCA, because if it doesn't, there'll be discrimination against Cecil and Total. So what I'm saying to you is when you say to me it contains many other terms, look at what is set out from paragraphs 1 to 4, and look at what is set out at the end of that letter. The intention of this agreement is to ensure that adjustments in crude oil and white product transport tariffs do not negatively impact on profitability of Netrea. What that really means is they're not paying a higher overhead for transportation. And where you're trying to take me in debate is to the first 2 sentences in paragraph 5, as if they exist in isolation, but they tell you the circumstances in which this letter agreement won't operate. But in saying that to you, they tell you it will be because it's replaced by another agreement embodying the content of the agreement.
But if the other agreement, as the subject to clause says, is to supersede the letter in any event, then what effect does the 3 years notice have?
You go back to it, you'll see that what they had was an intention to replace this with a more full agreement. And that's really what
but when the more full agreement comes, the subject to clause says that it supersedes the letter.
Yes.
So under what plausible circumstances would there be a full agreement superseding the letter and still have 3 years notice to disregard the letter?
No,
I'd just like to sketch a plausible scenario in which there can both be a full agreement and a 3 years notice, because it seems to me if everything turns on the full agreement, then one could just have had the subject to clause. You wouldn't have needed 3 years notice.
I agree with you. But what you got to do is you got to read the whole clause, because what is clear is they were looking for an agreement to embody the content of this agreement and supersede the letter.
But just give me a
what-
practical example. Give me a working example of 3 years notice that could be given.
The 3 years notice would be, it really, if you read it in the context of 5, it would be to give the parties the opportunity in that period to iron out the full agreement. That's what it would be to give them, and that's how it's written in this agreement. But it was
So you would give 3 years to terminate, to disregard this letter on the basis that we will have 3 years to negotiate a full agreement.
Negotiate the full agreement.
And if the full agreement, they can't come to terms on the full agreement, and the 3 years goes by, then the 3 years is operative.
Because there's nothing to supersede the letter agreement, and that's why that word supersede. The debate you have with me on supersede is quite important.
So in that practical example, after the 3 years and the parties have not reached a full agreement, would the notice then become effective? They can disregard the terms of the letter.
They can't disregard it because there's been nothing concluded to supersede the agreement. Otherwise, what you do
So there are no circumstances in which 3 years notice can be given.
No, if you read the whole clause, the 3 years notice is given, Justice Rogers, in order to give the parties the opportunity to conclude the full agreement. What you're postulating to me is the example Justice Madlanga gave, that to suggest that they could give it even on the basis that there's no conclusion of the agreement. They could then, on the day after this agreement, have given 3 years notice saying that for the next 3 years we'll sit and negotiate. If we don't conclude an agreement embodying the neutrality principle, the neutrality principle falls away, notwithstanding its justification remaining, and there's nothing between the parties. That could never have been the intention. And you read POC 4, that much is made even clearer. When it says, our understanding is these conditions will now be incorporated into an encompassing agreement between ourselves and Petronet with respect to the transport of crude oil via pipeline. Petronet will draft that agreement. The difficulty is you reading the first 2 lines of paragraph 5 in isolation from the rest of the document, the context in which it was concluded, and the very purpose for it. Because what you're reading is a potential escape route which allows Transnet to get away from giving effect to the tariff regime set out in that, even if the circumstances for that tariff continue to exist. And we say that that simply would be an absurd reading of this, once we've understood what the agreement was directed towards regulating. I now, thank you. Justice Madlanga, want to move. I said
now the 4 minutes.
Affordable portfolios is no authority for suggesting that when a party is in breach of claims on breach of contract, it is obliged to pigeon itself, hold itself into an enrichment claim. Affordable portfolios dealt with an enrichment claim simply because the plaintiff in that matter, or the party in that matter, it was in the counterclaim, the defendant in the counterclaim, chose to go by way of enrichment, and a court found that it did not meet the requirements. The principles set out in Victoria Falls, in mainline carriers, in Homedean Brickworks, that the starting point is to place the aggrieved party in the same position it would have been but for the breach, has always been a principle recognized by our law. That principle should not trouble this court. On that issue, there is no arguable point of law, less so one which is of general public importance. It arises between the 2 parties and ought not to engage the jurisdiction of the court. Consequently, Justices, we submit that having regard to the nature of the case sought to be made out on sections 195 and 217 in relation to the termination defense, and the reliance on affordable affirmative portfolios in relation to the special defense, you ought not to grant leave to appeal, quite simply because there's no arguable point. It's not of general public interest and shouldn't engage the jurisdiction of this court. But even if you do grant leave to appeal, you should dismiss the appeal. We would ask that that should be the outcome, and we would ask for it to be dismissed with costs, including the cost of 3 counsel.
Three counsel, Mr. Baum.
You know, costs are always in your discretion. We've engaged three counsel. It's a matter of some moment, but I'm indicating to you that it was worked on by three counsel having regard to the significance of the issue. But costs, as you know, are always within your discretion. I'm not going to spend another minute.
Thank you. Thank you, Mr. Baum.
Justice Madlanga, if I may, please, just one question for Mr. Baum. Mr. Baum, Total says that paragraph 5, the cancellation clause, permits the parties to agree on a different formula to give effect to the neutrality principle. Now, is your client's position that there must be agreement on the new formula before the agreement can be cancelled?
If it embodies the principle, yes. Well, you can give notice, but you can't supersede the variation agreement. And the question of, can I take it further, Justice Ron? The question of whether it embodies the content may become a justiciable question. In other words, it may well lead to litigation, whether it embodies it or not, and then you're going to have to lead the evidence. But the principle that you've got to embody is one which ensures that Total and Cecil are not at a disadvantage in relation to their competitors on account of using the pipeline to transport crude oil.
Now, on that principle, as you put it, is the interpretation, or does the interpretation adopted by the High Court and by your client not mean then that that cancellation clause contains an unenforceable agreement to agree?
No, it doesn't. And the reason it doesn't is because the substance of the agreement is embodying the contents of the letter. In other words, the enforceable obligation, the material provision, is the content of this letter, namely the variation principle.
But then that agreement would remain in place until the parties agree. Is that what you are saying?
And if there's a difference on whether it embodies the neutrality principle or not, that difference may well become a point of dispute, which they would have to fight about. But they've got to have a replacement which embodies the neutrality principle.
Thank you, Mr. Baum. Thank you, Justice Ndlanga.
Thank you, my sister. Thank you very much, Mr. Baum.
Thank you, Justices.
Mr. Nkaitobi.
Thank you, Justice Madlanga. What I propose doing is dealing with two questions. The first is why jurisdiction of the court is not engaged. And the second is dealing with the interest of justice, particularly in reference to the 2 points that have been raised by our learned colleagues and also the issue of prospects of success. But in the light of what has happened this morning in particular, it's necessary to set out what is before the court and what is not before the court. So the primary question is the validity of the notice of cancellation issued by Transnet. The court will find that notice at volume 3, volume 2, page 211. And the specific cancellation passage in that letter is the last paragraph, the third paragraph rather. It says, under that part of the agreement constituted by the letters put up, Transnet has the right to cancel the agreement subject to 3 years written notice of such intention. In accord with such right, Transnet hereby gives notice that it will cancel the agreement with effect on the lapse of 3 years, calculated from the date of delivery of this letter. So that is what set the trigger for the litigation that followed. Now, it's necessary to understand what was before the High Court, what is before this court, and to distinguish it from what has been argued in both in written argument and in oral argument. Firstly, to understand what was before the High Court, we must remember that there was a separation under Rule 33, sub 4, and the separated issue appeared clearly at pages 76 to 79, which would be volume 1. But if we can just go there, just to make sure we understand what was before the High Court. We are at 76, which is the order, 77, the draft order, and the specific paragraphs are at page 78. So those were the separated issues. In relation to the total claim, it was the special plea of Transnet, paragraphs 1A to 1G. In paragraph 2.2, the specific paragraphs were set out in the particulars of claim and in the amended plea. And paragraph 2.3, and that's where the termination issue arises. In other words, the validity of the notice that was issued by Transnet. The same point with the Sasol action, the issues that were before the High Court, in other words, that were separated for decision, are at 3.1, 3.2, and 3.3. Now, what is important about that is if you look at the rejoinder, it is at 2.24, Transnet rejoinder replication, 21 May 2019, paragraphs 1.1 to 1.7, comma, and 2.1. The same is repeated at paragraph 3.2.4 as Transnet's rejoinder to Sasol's replication, paragraphs 1.1 to 1.7 to 2.1. Why that is crucial is if you compare that with the heads of argument that have been filed by Transnet under the introduction, where they raise the allegations of profiteering in footnote 1, you will see that firstly it's paragraph 1.8. Compare that to 2.24 and 3.24. You'll find that it ends at paragraph 1.7. And then you look at this next reference, 2.2. Again, compare that to those paragraphs. It's not included, to paragraph 2.24 and 3.24. Then paragraphs 3.1 and 3.2. Again, you do the same comparison, it's not included. You look at 3.24, again, the same comparison, it's not included. So all of those allegations that are set out there are just not part of what was separated before the High Court. In addition to that, you look at what is before this court. What is before this court is not paragraph 2.2 at all, nor is it paragraph 3.2. What is before this court on leave to appeal is 2.3 and 3.3. What that is about is the validity of the termination notice, which appears at page 211. So the scope of this inquiry is much narrower. It's narrow in the sense that it concerns one notice of termination issued on the 14th of September 2017 by Transnet. A claim that was made by Sasol and Total was that that notice is invalid because it breaches the 1991 agreement, because at the time of the issuing of the notice, it did not embody the contents of the letter as required by the 1991 agreement. The issue was even separated further, and all of the issues pertaining to the allegation of profiteering are simply not part of the separated issue, nor are they part of what is on appeal. This appeal is really about two issues. It's clear on the pleadings and in the application for leave to appeal before this court. Did Transnet issue a valid notice of termination or not? And the issue as to the enrichment claim, that issue simply does not engage the jurisdiction of this court. We did not understand the argument made to show in what respects that issue engages the enrichment claim. It is pleaded at page 333, which is at volume 4. It is pleaded at page 333. It's crucial to see how it is pleaded because it's not pleaded as an unjustified enrichment claim. It is at 1D at page 333, paragraph 1D. What they say there, firstly, they complain about an overpayment of 1 billion rands, and then they say the recognized remedies in law for a breach of contract do not afford the plaintiff the right to recover monies that it alleges it overpaid the first defendant, absent a cancellation of the contract. So what was alleged is that unless you cancel, you cannot claim the monies under the contract. The same with 1E, the plaintiff does not allege that it cancelled the contract. On the contrary, in terms of the other relief, the plaintiff wishes to enforce the agreement. That issue simply does not engage the jurisdiction of the court. It is not a constitutional issue. It is not a matter of general public importance on which a decision by this court is required. So it's quite clear that on the unjustified enrichment case, you should dismiss the application for leave to appeal on the grounds that it does not engage the jurisdiction of this court properly. That takes us then to the first and the only surviving issue that can legitimately be argued. Outside of everything you've heard, the accusations of what happened in apartheid, the accusations of profiteering, all of those are atmospheric. They have no bearing whatsoever on the narrow function that you should perform today. That takes us then back to the sole issue, which is the notice issued by Transnet a valid notice? Firstly, the applicants, they need to show that issue, the validity of one termination notice, engages the jurisdiction of this court. They need to show that the termination of that notice, of that contract by that notice, is a constitutional issue. That is what they need to show first. And they need to show that if it is not a constitutional issue, it nevertheless raises a matter of general public importance on which a ruling by this court is required. What we know is that on the first requirement, which is, does this termination notice engage, the validity of the termination notice engage the jurisdiction of this court? We know for a fact that Section 217 and Section 195 of the Constitution were never referred to in the pleadings. We know also that the authority of this court suggests that if you want to raise a constitutional issue, you must do so properly in the pleadings before the High Court. If you do not do that, you deprive the respondent an opportunity to engage with the constitutional issue. You also deprive the court the benefit of the opinions and the views of the lower courts. But you also damage the administration of justice because you are unable to ensure that proper evidence is led on the constitutional issue that is implicated. So those are the authorities coming from this court on why it's important to identify a section in the Constitution that has been implicated. My learned friend refers to the case of Jiba. I invite the court to read the case of Jiba. It, in fact, is completely in conflict with what they are suggesting. Jiba, in fact, Ms. Advocate Jiba's application, the GCP's application, rather, was dismissed on the grounds that it did not raise an arguable point of law or a constitutional issue, even when it came to the application of the Advocates Act, because it was found that the only issue was whether she was fit and proper to be an advocate, and that did not engage the jurisdiction of the court.
And
Mr. Conte also...
The 10 minutes is up, Mr. Ngwetobi.
Thank you, Justice Matlan. Mr. Conte also refers to the recent case of the Constitutional Court, Mediclinic. Of course, Mediclinic is vastly distinguishable because Mediclinic turned on a clear right in the Bill of Rights. The question was whether or not the measure in that case had implications for Section 27 of the Constitution. In other words, did it deprive the people living in the surrounding hospitals the access to medical services? Here, we have, for the first time on appeal, a reference to Section 195 and Section 217 of the Constitution. This is simply impermissible. You cannot wait until the Constitutional Court and plead a constitutional issue for the first time. My learned friend's retort, certainly in oral argument, is to say we referred to public policy, but that is not enough. A mere reference as an alternative ground of pleading to public policy does not convert a case which is not about the Constitution and make it a constitutional case. In fact, 3 days ago, Justice Madlanga delivered a judgment in which he says that you cannot dress a point that is not about the Constitution in constitutional garb. You cannot simply give a gown and say it is now a constitutional point because I've called it. If they wanted a constitutional point, they would have raised it. This was in 2018, not in 1996. So they know what the rules of the game are. So on point one, they have demonstrably failed to raise a legitimate constitutional point that would engage the jurisdiction of this court. This case, we must emphasize, is about the validity of one notice issued in September 2017. That notice applies in respect of Transnet, Sasol, and Total. It has nothing to do with anybody else. They also fail in relation to the second ground. They fail to show that there is a general matter of public significance. Remember that in Tigadry, what this court held, in fact, both in the judgment by Justice Cameron, which is concurred in by Justice Jafta, what they say in that case is that if you are engaging a contractual issue, you must show that its implications transcend the interests of the parties immediately before the court. That is a crucial safeguard. Otherwise, everyone with a contractual issue rushes to the Constitutional Court where they don't like an outcome. And that also is emphasized in Bidika. Bidika is to the same effect. Also emphasized more recently in the University of Johannesburg case. So that guideline, in the UJ case, it's paragraph 51. Tigadry is cited at paragraph 14.5 of our heads of argument. The principle is simple. If you are dealing with a contractual dispute and you want to engage the jurisdiction of the Constitutional Court on GPI grounds, what you are required to do is to show that the contractual problem that you have has public significance wider than the implications of the parties immediately before the court. This case, particularly clause 5 of the Impugn Agreement, is only a fight between Transnet and my clients and Total. No one else.
Does the fact that it involves an organ of state and in a sense, therefore, may have a bearing on the public interest, does that not come into the equation?
No, Justice Madlanga, we would say with respect, it doesn't, because if you adopted that approach, you subordinate the test into looking at the nature of the party, whereas the test is to look at the nature of the issue that is at stake. Because the state can enter into agreements as the state, but once it enters into those agreements, the relationship is regulated by the agreements. So you cannot adopt a test that says, in order to decide if the issue, quote unquote, is constitutional, I need to look at the player. I need to look at whether the state is involved. You would have a problem otherwise, because the state would always come to this court and it will say, I'm the state and therefore I'm entitled to have my ordinary contractual fight adjudicated by the Constitutional Court. So we would say, with the greatest of respect, no, it doesn't. In the University of Johannesburg case, where the principle is re-emphasized, even there, the focus at paragraph 51 is look at the nature of the issue. Do not look at the identity of the party. Looking at the identity of the party always creates a problem because you give preferential treatment to the state in all circumstances. We would concede that if the issue gave rise to wider public significance, the fact that it would be the state or a private player would be of no relevance because the issue itself would transcend the interests of a contracting party. So that is the answer to that.
So Justice Madlanga, may I follow up on, are you finished?
Yeah.
Mr. Ngukatobi, I understand that the mere fact that one of the contracting parties is a public entity may not be enough, but may the public interest not be sufficiently engaged if the welfare of the public is, through the activities of the public body, affected by the answer to the question. So take Transnet, for example. It raises money in order to provide services ultimately for the public benefit. If it is locked into a perpetual contract on terms which it regards as unduly favorable to Total and Sasol, and if assuming for the moment that the point of law, the interpretation of clause 5 is arguable, and assuming even that Transnet is right, potentially the answer to this question will affect billions of rands over a number of years, which in turn affects Transnet's ability to provide services. In principle, is that not a basis for making the answer to a legal question a matter of general public importance? And I thought of that because it seems to me the judgment in Slipknot is not categoric about saying that the only way in which general public importance is established is where the legal question would be replicated potentially in other situations between other parties. They quoted a passage which talks about this jurisdiction will be engaged provided only that, this is the answer to the question, its impacts and consequences are substantial, broad-based, transcending the litigation interests of the parties. Now, isn't the public interest implicated by the answer to clause 5?
No, we would say, Justice Rogers, it is not implicated for two reasons. The first is that the issue as to whether or not the interpretation of the agreement, in other words, the meaning of clause 5, that has no financial bearing on anyone. It is not even the case of Transnet that the simple issue of the meaning of that clause has a financial bearing. Now, I'll come back to this because it's slipped into their heads of argument, and it has been repeated in oral argument today, that Transnet potentially faces liability of some 2 billion rands. It's crucial to recognize that that liability has nothing to do with the right of termination. It is to do with a portion of the case that does not arise before the court. So the question is, does a termination of an agreement by Transnet in circumstances where the termination notice is in conflict with an agreement that they have reached, does that give rise to an issue of public importance? So the answer is no, because there are no funds implicated by the giving of notice. We must keep focus on the giving of notice. Secondly, we have absolutely no evidence that the issue at stake here implicates anything beyond these three parties. You know, the example that was made in Tigidrai by Justice Cameron, he says sometimes, even if the agreement does not transcend the interests of the parties, sometimes it would be a standard clause that is capable of repetition across the board. And he says in those cases, the jurisdiction might be engaged. But even there, he is quite clear that if the contract is only of concern to the immediate parties before the court, the jurisdiction will not be involved. And take a private player that says, actually, my exposure is 3 billion rands. It is not 1.8 billion rands. If you started focusing on how vast the sums are, you are going to lose the test, because the test must always be, what is the nature of the dispute before me? If the nature of the dispute is just a fight between Transnet and the contracting party, I'm not interested, because you have to safeguard the jurisdiction of the court, because otherwise every second dispute will come to you and everyone will say, yes, unlike Transnet, I'm exposed to 2 billion, to 3 billion, and you will never arrest that impossible trade. So I would say for two reasons. In this case, there is no evidence that the termination has any relationship whatsoever to any potential financial exposure on the part of Transnet. This is simply about the validity of one notice against one party by one party. Secondly, there is no evidence that there is public funds that are implicated whatsoever. the 2 billion rands that has been repeatedly referred to by Transnet does not arise as a consequence of the termination. It arises as a consequence of a financial claim for overcharging that has been instituted by Sasol and Total. It is not before you at all. It's not before this court. So these two things must not be conflated and confused into the validity of the notice issue. And that's why I characterize the issue to be decided before Justice Soga as the validity of the notice issued by Transnet. So even on that generous reading that you postulate, Justice Rogers, I would still say that your jurisdiction is not engaged, and we must be clinical about the facts upon which your jurisdiction is potentially engaged. In fact, it's necessary to look at the order by Justice Soga, because the order is actually specific. It says that notice is invalid. That's what is before the court. It's the judgment itself. So the order appears at page 63 at volume 1. It's 72.2. It is declared that Transnet's purported cancellation of the variation agreement on 14 September 2017 is invalid and ineffectual. That's the issue that was before Justice Soga. It's one notice, and it has been declared invalid and ineffectual. Imagine if everyone whose notice has been found to be illegal rushed off to the Constitutional Court. You would have no time to do really deserving Bill of Rights cases. So we say on the 2 points, you have no constitutional jurisdiction, you have no general GPI jurisdiction. We say you should not be enticed by the references to 1.8 billion rands because they bear no relevance whatsoever to the issue of the termination. We say that you should not be interested in the allegations of profiteering, which have been used to supplement an otherwise thin jurisdictional argument, because those fall outside the scope of what was before the High Court, even narrower a scope that is before this Constitutional Court. The issue is a simple one. Was the notice of termination valid or invalid? So you can safely refuse the application for leave to appeal on the grounds that your jurisdiction is not properly invoked. Mr. Baum has spent a considerable portion of his argument dealing with the context in which the agreement was concluded. We fully endorse that argument. What really remains are issues about interest of justice. In other words, should you hear the case on interest of justice? Now, we emphasize the point here. Interest of justice is not a free-floating legal principle without constraint. One does not say, I want to hear every case under the sun because of the interest of justice. Interests of justice are tied or grafted into a specific jurisdictional basis, either because it is a constitutional matter or because it is a matter of general public significance on which a ruling by the court is to be decided. Only at that point do you then say, let me look at whether or not, if it satisfies one or two, what the interests of justice say. So the argument we make on interest of justice is that even if you were to conclude against me on what I have suggested are the jurisdictional blocks against this case being heard, you should not have regard to the interest of justice. Now, if you look at the heads of argument by our learned friends, the interests of justice are tied in to profiteering. And I've shown that the profiteering allegations are simply outside of scope. In any event, the evidence of Mr. Crowley had nothing to do with profiteering, just nothing to do with it whatsoever. And I've also shown that the allegations pertaining to the 1.8 billion rand simply do not enter the equation whatsoever. So there is no interest of justice related to profiteering, nor are there interests of justice related to the 1.8 billion rands. What then remains is one other possible avenue for the interest of justice, which is the question as to whether or not there are nevertheless reasonable prospects of success. Now, we must again remember what happened in this case. The way in which the case is pleaded in the application for leave to appeal is that the ruling by Judge Tsoka has created a perpetual agreement. It's because of the perpetual character of the agreement that the jurisdiction of the court is engaged. And it's because it's perpetual that there are reasonable prospects of success. That's the argument, that's the criticism that is made. What we had today, we had an extra layer of argument, which now criticizes the agreement for vagueness. We must make it clear, there is no case made for vagueness. There's no case made that the agreement is unenforceable because it's vague. The case that is made is that it may be an agreement to agree or it is perpetual. Now, if we look at the judgment by Justice Tsoka, I'm now dealing with interest of justice point 3 insofar as it refers to prospects of success. The cardinal paragraph is paragraph 66, which is page 60, volume 1. This is what Justice Tsoka finds. He says that the variation agreement is not in perpetuity appears from the terms of the agreement that specifically spell out on what basis the terms of the variation agreement may be disregarded. So the first point that is made by Justice Tsoka is that the variation agreement is not in perpetuity. And then he continues, so long as a full agreement of conveyance for crude oil is being prepared and such agreement will embody how the tariff is set out, either party is entitled to give the other parties 3 years notice of its intention to disregard the terms of the variation agreement. So he again takes us back to clause 5 of the variation agreement. And he says, these are the conditions precedent to the valid exercise of the power of termination. Because we must remember, this case is about the validity of the notice that was issued by the Transnet. It says you go back, you look at the letter, the 1991 letter, you look at the termination of the 14th of September, 2017, you compare the two. If there is variance, there is invalidity. Our learned friend, at least in their heads of argument, even though they didn't do so in oral argument, have lashed upon the line that follows, absent the full agreement of conveyance of crude oil, any attempt to cancel the agreement is ineffectual and of no consequence. Now, of course, that is true, but that full agreement is the full agreement referred to in the preceding sentence. In other words, it's the agreement that is being prepared, and it is the agreement that will embody how the tariff is set out. But we know for a fact is that at the time of the issuing of the notice on the 14th of September, 2017, there was no full agreement being prepared. There was no such agreement embodying how the tariff is set out. And there was no such agreement embodying the terms of the 1991 letter. And for that narrow reason, the termination letter that was issued was invalid. And that is what he is referring to when he says absent the full agreement of conveyance of crude oil. Any attempt to cancel the agreement is ineffectual and of no consequence. And if I can make one point here, which is so crucial because I realize in the course of the argument that there is movement between different types of the agreement. If you go to the actual letter, the letter of the 1991 letter, 132, at page 132. In fact, it's 131 up to 132. If you go to that, yes, 130 to 131, that's where the letter is. So you see at 130, at paragraph 2, the first reciprocity obligation is this. Sasol undertakes to make use of Petronet pipeline services for conveyance of its natural crude oil requirements between Durban and Sasolburg and between Kendal and Sasolburg. Now, Mr. Bam has explained the context in which this was agreed. So it's firstly my clients that are undertaking to use a facility of Sasol. But that's not what the agreement is about, the agreement we're dealing with. It's not the conveyance agreement itself. You then go into the following page at 131, which is paragraph 5. It then says each party shall give the other at least 3 years notice of any intention to disregard the contents of this letter subject to the arrangement that a full agreement of conveyance, so in other words, the agreement of transportation for crude oil is being prepared, and that such agreement will embody the contents of this letter and supersede this letter. So the contents of this letter as a whole, from paragraph 1 to paragraph 5, will be embodied in the full agreement. And that agreement would, in the future, supersede the contents of this letter. And it's easy to know why it would supersede it, because the parties would, by that stage, have reached an agreement. So to come back to the narrow issue before Justice Soga, which is set out at paragraph 66 of his judgment, was he correct or wrong to say that the letter that you issued on the 14th of September 2017 was invalid? I mean, it seems obvious that he was correct, because on any interpretation of the letter of at page 130 and 131, on any interpretation of that letter, Transnet's notice just did not comply. Whether one says there should have been a draft agreement, whether one says there should have been a full agreement, the fact of the matter is that Justice Soga was correct in saying that specific notice that you have issued is an invalid notice.
Mr. Logatobi, sorry, may I interrupt you on this aspect? Of course, what we're talking about here is the preparation of an agreement, not a conclusive agreement, one that's already been concluded.
Yes.
That's all. But then
yes.
The argument for Transnet is that this leads to an absurdity, because what it means, what clause 5 then means, as you interpret it, means that you can terminate the agreement, provided that you've prepared an agreement that perpetuates the terms of the old agreement that you're seeking to terminate. Says that leads to an absurdity. What do you say about that argument?
Well, I mean, we don't see the absurdity, with the greatest of respect. I mean, if we look at the clause itself, each party, so we can do that, they can do it, we shall give at least 3 years notice of any intention to disregard the contents of this letter of agreement. So we agree here so far with Justice Rogers that a notice of termination can be given. And then it says subject to the arrangement. So in other words, it's subservient to that arrangement that a full agreement of conveyance for crude oil is being prepared. So that much is clear. In other words, at the time of the issuing of the notice, there must have been a full agreement being prepared. What should that agreement look like? That agreement must embody the contents of the letter, and it must supersede this letter. So that seems logical, and nothing absurd about the interpretation. And it's not difficult to work out why Justice Soga came to the conclusion that on any construction, whether draft agreement or final agreement, the bottom line is that the letter of the 14th of September 2017 was an invalid letter. Justice Majid, this is why.
Does that not lock Transnet into a perpetual agreement, as they say?
No, Justice Majid, it simply requires them on its terms, at least. If we look at paragraph 66, on its terms, at least, what it simply says, for as long as a full agreement is being prepared, and such agreement will embody how the tariff set out, either party is entitled to give the other party 3 years notice of its intention to disregard the terms of the variation agreement. So it's simply a trigger for the exercise of the right of termination. At that stage, you must have an agreement being prepared, and the terms of that agreement must be as embodied in this letter. So we wouldn't submit, with the greatest of respect, that that on its own binds them into an agreement in perpetuity. This is perfectly understandable if you look at the context in which this agreement is reached. What was happening in 1991, in paragraph 2, Sasol was undertaking to make use of Petronet pipeline services for conveyance of its natural crude oil requirements between Durban and Sasolburg, and between Kendal and Sasolburg. And that is why they needed enough time. And that is why what they wanted is, we want a guarantee that the conditions that are set out in this letter, and particularly paragraph 3, which is mainly the ratio, that says Sasol will advise Petronet of the ratio average of petrol, diesel, and AVTU yielded from crude oil, and this ratio will be applied to obtain the weighted average mentioned in one above. And then it talked about the current ratio. then this ratio will be communicated annually in order to take cognizance of any changes which would influence subsequent calculations. So it's perfectly understandable that you have these two parties. You have Sasol that has agreed since the 60s that it will not build its own pipelines from the coastal to the inland, and you have Sasol that is undertaken, we will use Transnet's own pipelines, and you have an agreement that says these are the rates at which we will be charging. And that's all perfectly understandable, that if you want to get out of it, these are the conditions in which you would be entitled to get out. And this is why the case before your lordship, the case before the justices of the court must be decided on leave to appeal, narrowly on whether or not the notice that was given by Transnet on the 14th of September is a valid notice. That's the only issue that Justice Tsoka decided. If there is a further fight in the future about a new notice, this court should not foreclose that new notice in the absence of evidence. We don't know what the new notice would look like if Transnet is going to terminate again. We don't know what evidence is going to be led before the High Court. And we don't know what judgment will be delivered by the High Court in relation to the new notice. But at least in this case, you can be reasonably certain that the notice that was issued by Transnet was correctly invalidated by Justice Tsoka.
Mr. Ngagaitobi, I just want to get clarity on the preparation of an agreement and also the issue of a final agreement. At what point would a party to the agreement be entitled to, let me use the word used there, disregard? Would it be merely upon preparation or upon actual conclusion of an agreement? At what point exactly?
Yes, we've taken the interpretation consistent with Judge Tsoka that it is at the preparation. In other words, as long as the agreement is being, it says it is being prepared, and the contents of that agreement embody the contents of this letter, and they will supersede this letter at the point at which they have been agreed. At that point, we've taken the interpretation that that letter of termination can be issued.
So Transnet could all on its own put together an agreement that has the ingredients that you've just referred to.
Yes.
And the day after or in the afternoon of the day it has delivered it to the other parties, could then give notice or?
Yes, we've made that argument in our heads of argument that if you look at the notice they issued, that notice was plainly non-compliant, and it was rightly found to be non-compliant. But it was
I just want to, yes, no, I get that. But I just want to, in practical terms now, the document prepared by Transnet is ready, and it has the ingredients that you referred to, which are captured towards the end of paragraph 5. It contains those. And Transnet delivers that to the other parties to the agreement in the morning, and in the afternoon it gives a notice that I give you notice, three-year notice that now I will disregard. And then that is valid.
Yes. I mean, one of those requirements, of course, is the 3-year, because it must contain all of the elements of that letter, which includes the 3-year notice itself.
Contextually, purposively, and whatever other word one can think of, what purpose does that serve? Just having that piece of paper prepared only by one party and then just given to the other side, then, you know, having this very important consequence of being able to terminate. What's the purpose of that? What in practical terms, just why should that be so?
Yes,
at an interpretative level.
Yes, but the argument we've made, Justice Madlanga, is the following. We've said that one, the very purpose of that clause was to take into account of the fact that enough time was necessary for Sasol to make a decision about what it wants to do. Secondly, on a proper construction of that clause, the period that will be required is, in fact, that's what the parties agreed, that the period that is required under clause 5, which is the 3-year period, and on a proper construction is actually a 6-year period, because the 3-year period must also be included in the draft agreement that is being prepared. So that is the period that the parties elected, and that becomes a justiciable issue. And if the parties ultimately decide we would rather go to court and have a dispute about this, well, then that's what the parties have agreed. So we would say that there is no absurdity that arises from the fact that there is a draft agreement being prepared, and that draft agreement incorporates the terms of the entirety of the letter.
Sorry if the presiding justice has completed his question. Does that practically mean, I see, unlike Mr. Baum, you accept that the 3-year notice period could legitimately be a feature of the full agreement prepared by Transnet. If assuming the full agreement also was compliant with all the other principles in the letter, and it was immediately acceptable to Sasol and Total and was signed within a couple of days of the letter agreement, then immediately Transnet could have given 3 years notice in terms of the agreement on which the ink had only just dried.
Yes. I mean, this is the oddity of this case, is that you have a non-compliant notice, and instead of Transnet seeking to comply with the agreement, it has applied for leave to appeal to the Constitutional Court. And that is why you should, in fact, not grant leave to appeal at all, because the gates, the keys to the gates that they say is locked are actually in their pockets.
Isn't the oddity, though, that this oddity arises because of an interpretation you give to clause 5, which is to make the giving of a 3-year notice subject to a condition. Whereas an alternative reading is to interpret the subject clause as merely stating a state of affairs. It doesn't say subject to the condition that a full agreement must be prepared. It merely, the phrase is being prepared is merely a recordal of a current state of affairs. It is not setting a condition. A condition would normally say you can do X on condition that Y happens or that Y occurs. But the subject to clause is merely saying, recording an existing fact that an agreement is being prepared. So would one not read it, given that it's written by a business executive rather than a lawyer? The subject to clause could be reframed: we record that a full agreement of conveyance is being prepared, and that such agreement will embody the contents of this letter and supersede this letter. In other words, it's just a recordal.
No, we don't.
If it contains any term, it is the, if I may say, self-evident term that a full agreement will supersede the letter.
Yes, we don't accept that interpretation because it ignores the actual text, the language that was used by the parties. We don't think much turns on the fact that it was not drafted by a lawyer, because we know nothing about precisely how the letter was generated. And there is no evidence before us about how it was generated.
It was an exchange of drafts. It was.
Yes. Well, I'm told that on the evidence before the High Court, there was evidence that there was in fact an exchange of drafts before this was finalized. So it seems to have been given some consideration. But the critical point is that you cannot disregard the language of the agreement itself. And when the words subject to are used, we've dealt with this from paragraph 84 of our heads of argument, where we say subject to is usually used to create a suspensive condition. That is its conventional contractual meaning. And so we prefer there to footnote 111 and the judgment of the old AD, and most recently the judgment of the SCA. When you see the words subject to, it is by interpretation a resolutive condition to highlight a material term. So therefore, the use of subject to itself reflects a conditionality which would be applicable to either party attempting to terminate a variation agreement. So in effect, what it would mean is that neither party can terminate unless, and then the conditions are set out. And those conditions are threefold. They seem to have been embraced entirely by Justice Soga. The one is a full agreement of conveyance, and I've made the distinction clear between the full agreement of conveyance and the agreement around the tariffs, and the two must be kept separately. And then second agreement, it will embody the contents of this letter. And third condition, it will supersede this letter. Of course, the one about superseding it is obvious. Otherwise, the interpretation that you put with the greatest of respect, Justice Rogers, would undermine the contextual framework that was argued so eloquently by Mr. Baum. And so we would say that if you look at the context of the agreement, you look at the specific wording, and you look at the purpose of the agreement, which is implicit, if not explicit, from the terms of the letter itself, you don't get to an absurdity situation, nor can you be entitled to disregard the words that are used in the agreement. And you cannot take
Mr. Ngaitobi, sorry, my brother, Justice Rogers. Your 45 minutes was up 2 minutes ago.
Thank you, Justice Mandanga.
How much more time? How much more time do you want? I know, of course, we are engaging you, but from where you are sitting, how much more time do you want?
I in fact had finished the argument. I think probably an extra 5 minutes. I don't think there's anything substantial that I wish to add other than to answer the questions from the bench. So perhaps I could listen to the further point that Justice Rogers has.
Yes, I accept one must have regard to words, and you are emphasizing the words subject to. But one, in order to know what they mean, one must also look at the content of the subject to expression, which is here a statement that a full agreement is being prepared. Now, to formulate that as a condition, you would have to say, subject to the arrangement that a full agreement must be prepared.
Yes.
Whereas is being prepared isn't the formulation of a condition. How would you formulate that as a condition? You'd have to change the words, wouldn't you? Doesn't that simply refer to what is currently going on?
No, Justice Rogers, there are two problems with that possible interpretation. The first one, obviously, it says at the time, in other words, at the time of the notice period. In other words, when will you give notice? That's what the clause 5 is about. It's not today the agreement is being prepared. When will you give notice? It says each party shall give the other at least 3 years notice of any intention to disregard the contents of this letter, subject to the agreement that a full agreement of conveyance for crude oil is being prepared. So at the time you give notice, which may be on the day you wrote the letter, which may be today. So the problem is the grammatical shift to take the language used in this to say, well, it's present continuous tense, and therefore it must mean that on the day the letter was written, when the letter is referring to, when will you give notice? So one, at the time you give notice, the agreement must be prepared. And then it says, what will that agreement deal with? It must deal with, embody the contents of the letter, and obviously in the future, if it is signed, it must supersede the letter. So there is no problem with the conditionality phrased as present continuous tense. In fact, it's been a useful exchange because it is a point I wanted to make that the problem is that the context that is taken out of it is that it assumes that this is referring to at the time the letter was written, when in fact it is talking about the time of the notice period. What has been said?
That is itself a matter of interpretation as to whether it's referring to that or to a current state of affairs. The letter of acceptance seems to suggest that it was something that was going to happen there and then. It wasn't something which, if a person wanted to give notice, they would suddenly wake up to the idea of drafting a full agreement.
Yes, no, we can even accept that. In fact, I was going to go to page 132, because if you look at page 132, the second paragraph, it says, we confirm that the conditions as set out in your letter are acceptable to us. So it's clear that they understand those to be conditions. It says, our understanding is that these conditions will now be incorporated in an encompassing agreement between ourselves and Petronet with respect to the transport of crude oil via pipeline. Now, it doesn't mean that if you missed the train on the 2nd of December, 1991, the conditionality falls away. The conditionality remains. That is what the letter of acceptance refers to. It says, it is our understanding that Petronet will draft such an agreement. So there is nowhere in these two documents at 131 and 132 where you get any sense that the conditionality ever fell away. Obviously, it commenced at the giving of the notice, and it recorded that at the time of the notice is being given, the agreement is being prepared, and Petronet, Sasol accepted this and said, we understand that you are preparing the agreement, but there is nowhere where you can find anywhere where these conditionalities have been waived or these conditionalities fell away. There's just no basis for that interpretation whatsoever. Justice Rogers, I come back to where I started with this debate on prospects of success. You have to stand back and ask yourself the question, should I grant leave to appeal in this case? And if so, on what constitutional basis, on what GPI basis? This case is about the validity of one notice of termination. There is no one out of all of the three advocates that have spoken today, there is no one who has defended the termination as being a valid termination, because everyone accepts that on any interpretation of the agreement, the termination is invalid. The only way to defend the validity of the termination is to say that it is not subject to any conditionality. The only conditionality it is subject to is that it will supersede the letter. But that interpretation is an absurd interpretation. It's inconsistent with the language of the contract, inconsistent with the contracts, and inconsistent with the conduct of the parties subsequently. For 25 years, we've actually acted in accordance with the contents of these two documents. So in those circumstances, on what basis are you going to grant leave to appeal to this case? This is a fight between Transnet and Sasol and Total. And that is why the case ought to be decided on leave to appeal. The paragraph 66 of Justice Stoker is correct. If a further notice is issued, that will be subject to adjudication at a later stage, not now. And so the correct outcome is that you have to dismiss the application at leave to appeal stage on the grounds inter alia that there are no reasonable prospects of success. And in any event, there is no dispute that can capably engage the jurisdiction of the court. Can I just get 1 minute to ask my colleagues that I'm sitting with if they have any points, Justice Madlanga? Thereafter, I'll promise you I will shut up.
Mr. Ngai Toby,
Yes,
just a clarification for me. The Tsoka J judgment talks about the notice accompanying the full agreement, but that seems to be taking it, putting more of a burden than the language of paragraph 5 seems to suggest. It's, from what I gathered from paragraph 5, it seems that so long as an agreement or an arrangement for conveyance is being prepared, yes, then the termination is valid. Then yes, there's an assumption that if Transnet were to issue the notice, that preparation is underway. And that's all that is required, because there's a guarantee embedded there that it would be for conveyance, it would be an embodiment of all the terms, and that agreement that is being prepared will be superseded, will supersede the letter. That's all that's material to the validity of the notice.
Yes, Justice Pillay, you are right. Let me just put two qualifications. The first one is that the case made by Transnet on these facts is not that we had a draft agreement. Transnet's case is straightforward. We give you a notice of termination, end of the story. And so if you compare that versus the agreement, there is invalidity there. So Soka J is correct. The second answer is this. It is true that the clause is as you articulated, but you need evidence to show what is alleged. In other words, how do you show that there is a draft agreement that is being prepared? How do you show that that agreement embodies the contents of this letter? That is all done by agreement. And that's why Judge Soka was right in saying, produce the draft agreement so that we can see if it complies with clause 5. It's
a matter of proof.
Yes.
Because the most material requirements for certainly for Cecil and Total is that they have this pipeline conveyance arrangement. Yes. And if Transnet put anything else into the agreement, it was quite immaterial, however offensive that might have been.
Yes. Yes. That's why they needed to have the draft agreement, because they needed to see, have you embodied the contents of clause 5? Otherwise, it's impossible to work out if you have complied with clause 5 without a draft actually being prepared and produced.
And it's certainly not, in fact, it's quite the opposite of Transnet's case. It's not going to put up such an agreement. So it doesn't exist. It's not in the preparation. And that's the end of that aspect of the case.
And that's also the end of the appeal, if I may add, Justice Pillay.
Thank you, Justice Matlanga.
And Justice Matlanga, I still need my minute just to confer with my colleagues. Thank you. Luckily, Justice Matlanga, there is nothing. So that concludes my argument. I just want to thank the court for the patience and the time.
Thank you, Mr. Toby. Yes, Mr. Gauntlet.
Justices, Ms. Pillay will be delivering the reply for us, if she may. If I may, just before she does so, there is one factual aspect I would like to correct because it has been advanced a few times, a confined factual aspect. It relates to this issue of profit. Might I just say that why the issue of profit features is that, in summary, as Justice Rogers has also put it, there was unhappiness by the parties regarding, on the one hand, the clarity and what particular formula would be used, as has been said. On the other side, that changed over a period of time. There was uncertainty. Secondly, on Transnet side, there was the unacceptability of the fact that which was intended to create neutrality, in fact, resulted in a profit, a benefit not so contemplated. That need not be determined outright by the court. The fact is, though, that such a concern existed, lies in the immediate background or the circumstances surrounding the conclusion of the 91 agreement. It was a reason why there was pressure, at least from one side, to have an ability to exit that which had not been satisfactory. The factual point which has been made recurrently is that there is no evidence for this. That is wrong. First of all, the point was pleaded, as is acknowledged, I think, by our learned friends. They say, says Mr. Bum, at a late stage, etc. Well, they could have answered it and they didn't. And the references we've given to you, but it's in our footnote 151 to our paragraph 79 of the heads is the essential core reference. But as regards evidence, Mr. Crawley dealt with it. Mr. Crawley dealt with it in paragraphs in his witness statement, which is in the old volume 6, in paragraphs 140 to 146, 139 to 146, he deals with it several times. That witness statement was confirmed by him in his oral evidence, which has been admitted. There is that contradiction or discrepancy to which I drew attention as between the directives and the order, but you will find that at volume 6, the new volume 6, on page 426, at line 9, our predecessor recorded the order his lordship had made and asked the question whether Mr. Crowley confirmed these paragraphs, and he did. So there is distinctly evidence before court in that regard, and it was incorrect for the court to be advised to the contrary. That said, may I hand over to Ms. Pillay?
Yes, Ms. Pillay.
Thank you, Justice Madlanga, members of the court. Justice Madlanga, I intend to be quite brief in reply and only deal with the following topics. Firstly, just to make some brief remarks on what this case is about. Secondly, to deal with the PPA and what that act provides. Thirdly, I intended to deal with the evidence on profiteering. I see I've now been relieved of that obligation, but I do intend to make some brief remarks on the evidence that's before the court on profiteering. Fourthly, to deal with the SCA judgment of Lewis JA and exactly what that judgment dealt with and what's the implication of that judgment on these proceedings. Fifthly, I intend to make some brief comments on section 217 and the application of that section on these proceedings. Sixthly, to make just one or two comments about the enrichment action. And then lastly, to deal, and this is the seventh point, to deal with why some of the residual issues and why this court's jurisdiction is engaged. I intend to touch briefly on the question of public policy, on the arguable points of law, and most importantly, on the wider impact of the issues which this court is engaged with.
You opened by saying you'll be very brief. I can't see you being with that many points.
Trust me, Justice Madlanga, I really do intend to be brief. It's not going to be long at all. Perhaps I can start with the question of what this case is about. Now, you've heard submissions from my learned friend, Mr. Kaitubi, that this matter is really confined to the termination notice, which you find at page 211 of volume 3. And on his submission, because there's such a narrow point to the issues in dispute between the parties, firstly, this court's jurisdiction is not engaged, but secondly, it renders a lot and probably the bulk of the submissions made by my learned friend, Mr. Gauntlet, completely superfluous. Now, to take two steps back, Justice Madlanga, it is correct that what is before you is the question of the termination notice. But properly construed, what the real issue is whether Transnet had the right to issue the termination notice. In other words, did Transnet have the right to cancel? And once this court is engaged with that question, with the question of whether or not Transnet had the right to cancel, in order for you to answer that question, you would need to interpret the 1967 agreement, because we know that the 1991 agreement is but a variation of that agreement. So you would need to interpret the 1967 agreement. You would need to interpret the 1991 agreement holistically, and then specifically drill down to clause 5. Now, you will immediately appreciate that the exercise that's before you is far more complex than interpreting one piece of paper at page 211 of volume 3. Because, and this is exactly what this court held in the UJ matter, in order to understand and to answer whether or not Transnet had the right to cancel, this court must have regard to context and purpose. And it's in conducting that exercise, it's in looking at clause 5 within the broader context of the agreement that the submissions made by Mr. Gauntlet become apposite and really address the crux of the exercise that this court is engaged with. within that context, Justice Madlanga, if I can then move to the second issue, and that's the reliance on the Petroleum Pipelines Act. The court will recall that Mr. Baum relied quite heavily on the PPA to argue that, in fact, some sort of statutory right or injunction was created in the Act, which necessitated the variation agreement. And therefore, it was inapposite for this court to interpret the variation agreement in a way which entitles Transnet to cancel on 3 years' notice. If I may ask that the court open up the Petroleum Pipelines Act, and I did say I'm going to be brief, Justice Madlanga, and I will do that. Just to emphasize just a few features of the Act, because I think it's important that the Act be considered contextually and as a whole, rather than just isolating one specific section of the Act. And the first is to focus on Section 2 of the Act, which sets out the objects. And the court will see that Section 2A provides that one of the objects of the Act is to promote competition in the construction and operation of petroleum pipelines, loading facilities, and storage facilities. So this is a very central feature of the Act, that rather than preserve existing contractual arrangements, that one of the objects is to promote competition. You see that reflected again in Section 2D of the objects, which states that one of the objects of the Act is to promote equitable access to petroleum pipelines, loading facilities, and storage facilities. Again, the court sees the refrain of equitable access, of fostering competition. You see it again in 2G, which is quite an important object because it states that one of the objects is to promote companies in the petroleum pipeline industry that are owned or controlled by historically disadvantaged South Africans by means of license conditions to enable them to become competitive. And I would submit it's self-explanatory why that is a critical object and why that links so clearly to the transformative ideals of the Constitution. So it's within that broad framework of objects of the PPA that one then goes into the specific provisions. And if you look at Section 4 of the PPAs, it establishes NERSA and sets out the powers and duties of NERSA. And if you look further, and I'm going to try and really be brief and just go to the crux, Justice Madlanga, if you go further to Section 20 of the Act, and this is, you will recall that this is the section that was relied on most heavily by Mr. Baum. This is what the section states. It states that NERSA may impose license conditions within the following framework of requirements and limitations. So all the section does, it does no more or no less than empower NERSA to impose license conditions on potential licensees. And in imposing those conditions, NERSA must have regard to what it describes as requirements and limitations. And we would submit that this is a far cry from setting out a statutory injunction, which would govern the contents of any contractual arrangement between Transnet and users of its pipelines. So what this says is, for example,
the 10 minutes, because it's inclusive of the little bit of time taken by Mr. Gauntlet, is up. How much more time do you want?
If I can have just 10 minutes, I intend to be very brief, but this was an important point raised by Mr. Baum. So I just want to take my time through this point and then 10 minutes, Justice Madlanga. If you look at Section 20, a number of what it's called requirements and limitations are listed. I just want to draw the court's attention to, for example, 21B, which talks about the fact that NERSA must promote historically disadvantaged South Africans. For example, if, and that's the one that Mr. Baum isolated and identified, is that they must ensure that the petroleum pipeline may be licensed for other crude oil or petroleum products, as long as sufficient pipeline capacity is available for crude oil to enable the uninterrupted operation of the crude oil refinery located at Sasolburg. And it's correct that at the moment that is NATREF. But what's critical is that the Act doesn't state that the pipeline has to be that which belongs to Transnet. Now, the court will be aware that the record is replete with references to NATREF considering the possibility of establishing its own pipeline, for example, or entering into contracts with other third parties in order to establish a pipeline. And it's significant that even if that eventuality were to come about, that this section would accommodate such a position. And again, if you were to look at G, for example, the shippers must have access to petroleum pipelines. And at H, it's an important one. It says interested parties must be allowed to negotiate changes with pipeline licensees in the routing size and capacity of proposed petroleum pipelines. So you would see, even in these requirements and limitations, that the PPA does envisage a more open market, a more competitive market. And it enjoins NERSA to have regard to those when it crafts its license conditions. The last section of the PPA, Justice Madlanga, that I very quickly want to flag is section 21. And that's the non-discrimination section. It says licensees may not discriminate between customers or classes of customers regarding access, tariff, conditions, or service, except for objectively justifiable and identifiable grounds approved by NERSA. So if there is discrimination in terms of the application of tariffs, the basis on which that discrimination takes place has to be approved by NERSA. The sharp point of the submissions on the PPA, Justice Madlanga, is that firstly, there is no statutory injunction which dictates the contents of subsequent agreements between Transnet and users of its pipeline. And secondly, all that these are is it's an empowering provision which allows NERSA to craft conditions, license conditions, to give effect to the objects of the Act. Important to bear in mind that one of the critical objects of the Act is transformative in order to transform the industry going forward. Then just briefly on the second issue I wanted to address the court on, and that's on the evidence of profiteering. My learned friend, Mr. Gauntlet, drew the court's attention to the three clear evidence that the court has on record, instances of evidence. The first is the statement of Mr. Crowley. It's important to emphasize that the aspects of profiteering and of locational advantage dealt with by Mr. Crowley is in the portions of his statement which the parties accept as common cause. So in other words, those particular sections of his statement, which is at paragraph 1.39, 140, 141, 1.42, 1.43, etc., those have been accepted by the parties as common cause. And so the court can properly have regard to those. The second point to be made, and you'll see in those sections, Mr. Crowley deals with what the intent of the VA was and what had subsequently occurred with Total and Sasol starting to profiteer and rack up large profits despite the neutrality principle which the VA very jealously tried to protect. The second issue, just to emphasize, is that the other two species or classes of evidence which we rely on, which is R2 and R3 of the replication, both of them are documents which are Sasol documents. So the one is an email from Sasol to Total, and the second is a submission prepared by Sasol. And it's significant that neither of these documents featured in either Sasol or Total's objection to the record or their insistence on certain documents being removed from the record. So those documents the court can accept are in by consent between the parties, and the court can have properly regard to those documents as agreed evidence before the court. Importantly, these both originate from Sasol. These are not Transnet's documents. Justice Madlanga, I'm moving very quickly on to the next point, which was the SCA judgment. During the course of the afternoon, there's been questions raised about whether or not the SCA judgment does dispose of some of the key issues raised in this appeal. And if I can ask the court to turn up the judgment, it's at volume 1, page 72. And specifically, if you have regard to page 74, volume 1, at paragraph 15 of the judgment, what Lewis J.A. does is she sets out in clear terms what the issues were that were before the SEA. And she says, on appeal, Transnet argued that the neutrality principle is not consonant with the provisions of the PPA, and that the basis of determining the tariff before its enactment cannot exist once together with that determined by NERSA in terms of the PPA. And that was the crux of the issue before the SEA. The issue was, now that the PPA has been enacted, can the provisions of the VA survive the enactment of the PPA? And the court crucially found that it can, because ultimately NERSA sets a maximum tariff, and Transnet was allowed to deviate from the maximum tariff. I have, however, taken you to section 21 that says that even if it does that, that the basis on which it does discount must be approved by NERSA. But for present purposes, I think it's important to emphasize that that was the context within which the court considered the neutrality principle and made findings on the neutrality principle. Now that's distinct and quite different from what this court is seized with. This court is seized with the proper interpretation of clause 5 of the variation agreement, whether or not Transnet has the right to terminate. And our submission and our argument before you today was that in interpreting clause 5, this court must have regard to the 1967 agreement, which sets out the neutrality principle, as well as the VA, which incorporates the neutrality principle and sets out the mechanism for the determination of tariffs. And so to answer a question asked by Justice Mklandla to my learned friend, Mr. Gauntlet, around clause 21 and 22 of the SCA judgment, it is correct that those clauses deal with the neutrality principle. It is correct that those clauses or those sections of the judgment deal with the question of differentiation and discrimination. But what we submit is that those findings have no bearing on the issues which this court has to determine, save that it's one of the contextual factors that must be taken into account. So in other words, there was no finding made by the SCA which has determined an issue for this court to now consider. And you will recall that that's one of the central bases on which we challenged the decision of Justice Tsoka and his findings that there were elements of Transnet's case which ran foul of the res judicata principle because there had been findings made by the SCA. Justice Tsoka was plainly wrong, and a simple reading of the SCA judgment will demonstrate that. And then very briefly to section 217 and why it's applicable to instances when organ of state contracts with another party to enable them to make use of its assets and or services. Now, my learned friend, Mr. Gauntlet, has already addressed the court on the AXA decision. Safe to emphasize that the relevant portions of the decision feature both in the minority judgment of Molamela J at paragraphs 22 and 23, as well as the majority judgment of Ponan J at paragraph 63. And in these paragraphs, what the judges of the SCA do is that they emphasize that section 217 does not only apply where it is the state entity that is procuring a service or purchasing an asset, and that it applies even where the other party, the party with which the state entity is contracting, even where it is that party which is procuring the asset or engaging the service. And the reason for that is very clear, and it comes through very strongly in the AXA decision. And that's because even where the other party is either procuring an asset or engaging the service, there is an exchange, there is public funds which flows to the state entity. There's funds which flows to the state entity. And by virtue of that transaction, this court must lean in favor of extending the crucially important components of Section 217 to such a transaction. And the court will see this theme being dealt with in the decision of Justice Rogers, the CEF decision, where in that case, the court found that Section 217 didn't apply to a public body's disposal of its assets. It made an important finding, though, and I just want to read, this is paragraph 205 of the CEF judgment. The court said, nevertheless, a public body must adhere to the principles of administrative justice and legality when exercising its powers. The values embodied in Section 217(1) should not be disregarded in determining whether a disposal decision complies with the public body's constitutional duties. Now, the court will understand that a decision to dispose is at the far end of the spectrum of transactions which we're dealing with. And according to the court in CEF, even in that case, that Section 217 plays a role, as well as the principles of administrative justice and legality. Now, it's for that specific reason, Justice Madlanga and members of the court, that it is crucial that this court grapple with this issue, whether or not, even if one is dealing with a transaction that is short of a disposal, as in this case, it's for use of Transnet's pipelines, that Section 217 and Section 195 play an important role. And just to tie that back, and I know I did say that at the end of this, I'll make submissions on jurisdiction.
Additional 10 minutes was
is about up, yes. Justice Madlanga, I literally need 30
It was
seconds.
up 4 minutes ago.
If I could ask the court just for 30 seconds, and this is literally the last point, and it's about the wider impact of this case. I've enumerated the factors which helps Justice Madlanga, because I'll get through them much quicker. And there are really 7 reasons why there is a larger impact to this case. And I'm going to run through the 7 reasons. One,
Please give me the time. It can't be 30 minutes. You said 30 seconds, I think you said.
It'll literally take me
points. You
1
can't
minute.
take 30 seconds to make 7 points.
I promise you it will, Justice Madlanga. I'm going to stake my life on it. It'll take maximum 1 minute.
All right.
All right. So the first is that the court is dealing with a large parastatal, a large state-owned entity. The second is that there are considerable public funds at issue. The third is that what this court decides will ultimately have an impact on the price at the pump. And this is a submission already made by my learned friend, Mr. Gauntlet. The fourth is that this judgment will have important implications for Section 217 and Section 195, and whether or not these apply to different types of state transactions. That's an issue which this court hasn't decided yet. At this stage, we only have decisions of high courts and the SEA. The fifth issue is around evergreen contracts and how the Constitution implicates evergreen contracts, particularly those which have been entered into before the Constitution came into effect. The sixth is that this case does implicate the PPA and the proper interpretation of the PPA, specifically the objectives of the PPA. And the seventh and final point you'll be happy to know, Justice Madlanga, is that this matter does implicate the interest of competitors and people who are also transporting or conveying fuel through different pipelines. And there is, at volume 3, page 263, the court will see evidence that coastal producers pay for pipeline transportation costs to get their products to the same depots and the same delivery points as Transnet. That's volume 3, page 263. So in other words, there are competitors whose interests are directly at stake. And so to tie it back up, there are issues which arise in this matter, and there are multiple issues, 7 of them, which transcend the interests of Transnet, Sasol, and Total. And purely on that basis, we submit that the court should lean in favor of granting leave. I'm hoping that was not more than 60 seconds, Justice Madlanga.
Please repeat
That last point was less than 60 seconds.
Thank you. Thank you.
As the court please.
Thank you to all counsel. Judgment is reserved. Court will adjourn.
Thank you.
Thank you.
Today's proceedings have concluded. The host will now terminate the meeting.